The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. Be seated. We'll be pleased to hear in our first case, 19-7795, United States versus John Jackson. Mr. Byrne.
Thank you, Your Honors. Good morning. May it please the court. My name is Jonathan Byrne. I'm here this morning on behalf of the defendant below, John Jackson. In 2019, when the district court ruled on Mr. Jackson's motion for relief under the First Step Act, the district courts were kind of struggling with how precisely to process those kind of claims. In the 3 years since, several decisions from this court and the Supreme Court's decision in Concepcion have clarified that First Step Act sentences are sentences pretty much like any other, that most of the same procedural requirements apply, the same analysis applies, and that includes review of those sentences for reasonableness by this court. The district court in this case made two errors that led to the imposition of an unreasonable sentence. First, the district court resolved a conflict over the applicable guideline range, but did not provide the parties with the additional ability to argue about the appropriate sentence in light of the resolution of the guideline conflict. And second, the court based its decision to impose a sentence at the top of the new guideline range instead of the bottom as it had done initially on Mr. Jackson's disciplinary record in prison, which had never been disclosed to the defendant. So either one of those errors, we think, requires the vacation of the district court's order and a remand of Mr. Jackson's case.
Can you start with that? Because that, I don't mean this in a bad way, but that seems to be false, right? What you just said, it seems to me to be wrong, which is that his disciplinary record was not disclosed to the defendant. I mean, it was his disciplinary record, right? I mean, he had it. He knew what he had been disciplined to and what that record was. He might not have gotten the copy that the court got, but it's his information, right?
It is his information, Your Honor, although we as defense counsel never got it, and the government didn't rely on it.
That may be different, but you said the defendant didn't know it, right? And what I'm trying to tease out is that line, and whether you think that could, the fact that you said he didn't know it suggests to me that you think that matters. And so I was trying to figure out why that matters.
What matters, I think, Your Honor, is that we did not know of it. Defense counsel, and did not know it was an issue. Because as I said, the government and their response to the First Step Act motion was largely boilerplate, and that's not a critique. A lot of the motions we were filing back and forth were boilerplate at that point. But they didn't make any argument that his new sentence should be X because of his prison record, and this is what it was. And so the first time we got any indication that there was a disciplinary record out there was when the district court is saying, I'm only going to impose a new sentence at the top of the guideline range because of this record.
How often, in your experience, you represent other defendants in First Step Act cases?
Yes.
Is that fair? Right. How often is there, post-conviction rehabilitation relevant, or does it come up in these First Step Act resentencings? I'd assume it's like 99.9% of the time. Is my sort of supposition wrong there?
No, Your Honor, I think that's right. And part of what occurred here is going back to 2019, our office is trying to process a bunch of these First Step Act requests, and particularly if we have people who may be released immediately, want to try and speed that along as much as possible.
But have you ever had a defendant that was being resentenced for any reason, right? So that it's not just First Step Act, but a Rule 35 resentencing or any other context in which a defendant is being resentenced, in which you didn't put forward whatever positive post-sentencing, developments have come forward, right? I mean, that's if somebody gets a GED right? I assume in every case, unless you're committing malpractice, you're providing that information to the court, right?
Generally speaking, Your Honor, yes. I think,
But I also assume that like you don't put forward to the court the things that are bad, right? I mean that's the nature of being a lawyer, right? You choose, but I guess what I'm having a little hard time seeing is your suggestion is that, well, we didn't know that his post-sentencing rehabilitation, or lack thereof in this case, was going to be relevant, that it was going to matter. And that strikes me as like hard to get my head around, that, you know, you're a good lawyer. You come obviously from a very good office. I think you acknowledge that in every single resentencing case that you've ever seen, what the guy's done in prison is relevant.
I would acknowledge that, Your Honor. I would say that the context of this case is that the attorney who handled it got it and said, oh, I don't think Mr. Jackson is a career offender anymore. His guideline range should only be 57 to 71 months. He's already done basically twice that. So that was the primary basis for relief.
Totally fair. And I don't mean this in a bad way, but he might have an ineffective assistance of counsel claim if in this particular instance the lawyer didn't think to look at, you know, post-rehabilitation conduct, right? Although here I don't think there'd be any prejudice given that he didn't find what we now know is there. But I'm having a little hard time understanding why, this is where we started, the point is that counsel didn't know, right? You started off by saying the defendant didn't know, then you went to counsel didn't know. And to me that seems hard because any like competent counsel, of which your office is more than competent, knows that post-sentencing rehabilitation or lack thereof is often the central question in these resentencings.
Not necessarily central, and it can be important, and I think it depends on the particular case. And as I said here, I think the driving factor here was we thought that his guideline range was now not just lower than it was when he was sentenced, but half of the time he'd already served, and that was enough. And that was, again,
right,
trying to process this.
That turns out to be wrong.
Yes, that's
right.
Correct.
And so, you know, the other thing criminal defense lawyers do really well is they make arguments in the alternative, right? I mean, that's the nature of your job is that, you know, he didn't do it, but if he did do it, he didn't know, right? And if he didn't know, then, I mean, you know, that's the nature of alternative arguments. Maybe you got that one wrong, but it seems like to me you had to know that his conduct post-sentencing was going to be relevant.
Obviously it was, in the end, Your Honor. But I think our position is that the error here is no one had crystallized that until the district court did it in the final order. And it would have been equally easy for the district court to have resolved the guideline range and said, there is this disciplinary record, I'm ordering probation to turn it over to the parties, file further briefing, and in which case we wouldn't be here.
Wouldn't it have been just as easy for counsel to have submitted a reply brief to the government's briefing on the First Step motion? It went 5 months and never said anything about the corrected guideline calculation. Made no argument at all. You say in your brief that the court didn't invite new argument and the court prevented this, but did the court prevent it? I mean, counsel didn't file a thing after the government's response.
Well, Your Honor, all I would say to that is that there is a difference between the government taking a contrary position and the district court resolving that in favor of the government. Because if this was a initial sentencing and everyone was there at a hearing, defense comes in and says he's not a career offender. Government comes in and says he is a career offender. Judge says, defense, you're wrong, he's a career offender, this is the guideline range. Then they would proceed to an argument about what the proper sentence was. And in this case, we've got this dispute that's hanging out there, and the district court resolves it and then goes on and does the rest of the 3553A analysis in the same order. And so didn't give the parties a chance, because it's a different argument, obviously.
Didn't we, in Collington, and I know this was after that, but in Collington, we explicitly said there's not going to be a requirement for a hearing in these First Step Act cases. So your argument seems to suggest that the court either has to hold a hearing, contrary to what we said in Collington, or the court in every case has to engage in a sort of two-step paper motion submission, right? The parties submit their arguments about the guidelines, 3553A, all the things that you did, you had an opportunity to submit, but then once the court decides the guideline range, it needs to ask for further briefing on the same subject, but within the court's decided range. Do you think that should be the rule in every case?
If I can back up just a smidge, we waived any right to a hearing in this case, and so I'm not suggesting the
Right.
court was required to have a hearing.
Sure.
And my experience with these cases has largely been that there is not a dispute as to the guideline range. There's
Well,
obviously
there's not one on appeal, right? Because now you admit that the
Well,
government was right.
no, I do, Your Honor, but I mean in the mine run of these First Step Act cases. But then in a situation where there is a dispute, and this was not a 2 or 3 year dispute, this was a 10-year dispute, that there is a situation where the district court needs to get argument from the parties based on the properly calculated guideline. What it concludes is the properly
So
calculated
what's the
guideline
rule?
range.
What's the rule? When is a court required by law to order supplemental briefing once it decides the disputed guideline range? You're saying there has to be a significant gap between what the parties are arguing for? What do we tell district courts to do?
I think the best practice is probably to do a second step in any situation where the guideline range is disputed. But certainly if there is a career offender designation or something that greatly increases the guideline range, then I think it's appropriate in that situation. Because we know from statistics that in the years after Mr. Jackson was originally sentenced, the percentage of within guideline sentences for career offenders has dropped precipitously. Judge Chambers frequently varies downward from the career offender guideline. And so it is an entirely different argument.
Well, and it's an argument that could be made in the alternative, right? If you see the government's response, and then you could file a reply brief saying, if the court adopts the government's guidelines range, we would make these additional arguments for why the court should depart downward. But there was no reply here.
That could have been done, Your Honor. That's true. I can't get around that. That said, I don't think that relieves district court from its obligation, as it would have in any other sentencing, to get the arguments of the parties after a guideline dispute like that is resolved. Because under Poly, sentencing is basically a 3-step process, and the first step is correctly calculating the guideline range. And the second step is soliciting arguments basically based on that. And of course, the guideline range is one of the 3553A factors. And so once that's set, if that changes the playing field significantly like it did here, I think it's incumbent on the district court, as I said earlier, to enter a second order and say, here's how I resolve the guideline dispute. What's your argument now? And particularly when we also have the issue with the disciplinary record, because that, regardless of what Mr. Jackson knew or anything else, that record's not in, or that disciplinary record was not part of the record when the district court made that decision. And the Larry case out of the Fifth Circuit that we cited in the brief, says that if the court's going to consider amended PSRs or reports from probation, those have to be shared with the parties. And so I think given the unique nature of this case, the district court had an obligation to go ahead and sort of have that second step. And excuse me. If there aren't any other questions, I'll save the rest of the time for rebuttal. Thank you.
Thank you, counsel. We'll be happy to hear from you.
Good morning, Your Honors. Nagar Kordestani on behalf of the United States. The defendant was put on notice nearly 5 months in advance of the district court's decision resentencing Mr. Jackson about the correctly calculated guideline range. The district court further went on, following what are now guidelines and rules for determining procedural reasonableness under Collington and related cases, and issued a correctly calculated guideline range and resentenced the defendant within that guideline range. Therefore, this court should affirm the lower court because the sentence was procedurally reasonable. The district court got it right following what are now the precedents in Collington and related cases about what to do when faced with resentencing a defendant under the First Step Act. A plenary rehearing is not required. Defendant said a few times, or defense counsel rather, just like at an initial sentencing. As the court noted, this kind of analysis for procedural reasonableness under First Step Act doesn't require a hearing, and the court so noted in its decision. The court correctly calculated the guideline range. The court applied the 3553A factors in considering how to resentence this defendant. It also considered changes in case law and also changes in fact, which can include a defendant's post-sentencing conduct, as noted in both Chambers and Concepcion, and it chose not to depart or vary in any way, so no further.
So can I go just sort of to get to the issue that strikes me as most interesting here?
Yes, Your Honor.
The post-sentencing rehabilitation, or lack thereof in this context, that's information that was held by the executive branch, right? The BOP had that information.
Your Honor, I believe, and the United States would argue, as you noted in a colloquy with defense counsel, that the defendant was singularly in the best position to know his own disciplinary record and his conduct.
Yeah, but he knows it, but the information is held by the Bureau of Prisons. That's where people, this is the Century system. I'm sorry, this was supposed to be the easy question. All right, so the Bureau of Prisons is what has his disciplinary record. I understand other people might have access to it, including himself, but the Bureau of Prisons has the Bureau of Prison disciplinary record, right?
That's correct, Your Honor.
And in this case, neither the defendant nor the government, that being the U.S. Attorney's Office, provided that information to the court.
That's correct in
Okay.
that.
All right, stay with me first.
Yes, Your Honor.
I'll give you a chance to answer. Instead, a part of the judicial branch went to the executive branch and got information that had not been provided by the parties, didn't tell the parties about receiving this information from the executive branch, and then relied on it to impose or to balance the sentence that it was going to choose. I mean, I just want to make sure that you agree, like, that's what happened here.
Yes, I agree that the information contained in the probation office's memo was not provided to either of the parties.
And that it came from the executive branch into the judicial branch.
Yes, Your Honor, from BOP originally.
All right, so if this was a full sentencing, so if this was the first go-around, do you agree that that would be impermissible? So in other words, if at a sentencing, the district judge has the probation officer or his law clerk go to the executive branch and ask for information about the defendant that is not otherwise disclosed, and then relies on it to sentence the defendant, that district court judge would be reversed for having done so?
In the case of an original sentencing, yes, because the parties should have an opportunity to be able to be put on notice and to be able to object if necessary to the factual record the court is considering at sentencing.
All right, and so so great, this is where I was trying to get, I just want to make sure we were in agreement. So help me understand why that's different in a First Step Act resentencing. We say, and your colleague sort of used the term, pretty much and mostly like, and that seems to be what we've said, and Collington, Concepcion maybe cuts back that a little bit. But there is still some suggestion that it's like a sentencing in some respects, right? And what I can't quite understand is how a First Step Act sentencing is so different that we would allow the judicial branch ex parte to go get information from the executive branch, which is a party before it, and rely on that information to sentence a defendant without letting either side know. And what I'm looking for is like, what principle would allow that to happen? Is there any case in which we've allowed a judicial branch employee or a judge to go get information from a party before it, ex parte, and rely on it to sentence a defendant?
Your Honor, I think the crux of the matter here, though, is what is actually required under Collington is that there, a hearing, and it's not a plenary rehearing, it's not an original sentencing. And so when
Totally fair, right? But the question is, so your view is the district judge can literally do anything ex parte. He could just call the AUSA back in his chambers and say, hey, let's talk about what we ought to do here. I mean, how can we like really give it to this guy? And then, right, all ex parte. And so tell me a little bit more about this guy. What do you know, AUSA, about this guy? And then send the AUSA out the room, write the order, and say, well, I now know all these other facts about the defendant that I didn't know before, and I'm going to rely on them to sentence. Could they do that in a First Step Back case?
No, they couldn't do that.
Why not?
Because, first of all, it would be ex parte and not permissible under ethical rules and procedural rules. But here, Your Honor, the probation office, the information it passed on to the court, it is a branch of the judiciary. It wasn't an ex parte situation where the United States...
But where did the probation officer get it from?
The probation officer got it from the Sentry system.
Which is a BOP system.
That is correct.
Which is part of the executive branch.
But I would point the court back to what it flagged during defense counsel's argument, which is the information ultimately that was considered, which the court has wide discretion under the relevant precedent to resentence, under Concepcion, under Collington and Swain. It was in the defendant's knowledge, as the court noted. He was in the best position to know it. And ultimately, Your Honor, I would argue that it would not prejudice him, even if this court were to send the decision back, send the case back for resentencing. The court, in its discretion, could consider and should consider and is permitted under both Chambers and Collington, both Chambers and Concepcion to consider intervening changes in fact. And when it did that at the resentencing, and I would submit what it would do if it was sent back, would resentence this defendant who had 35 separate infractions over the course of his disciplinary record in his post-sentencing conduct. It would resentence him to a similar within guideline range. So ultimately, it would amount to almost harmless error, if that.
Have you ever had an instance in which you were a lawyer and the BOP records were inaccurate? Have you ever seen the BOP get something wrong? That's rhetorical. You don't need to answer it, right? All right, so I hoped it was rhetorical.
Thank you, Your Honor.
So maybe there are 35, right? But the point is that the defendant gets a chance to tell us whether that's right or wrong.
And the defendant here had the chance in the sense that, again, I would point to ultimately he was in that position to best know what he did, and the court would, if sending it back, would ultimately, most likely in its wide discretion, and it could focus on other factors for resentencing if remanded, but it could focus on many different things, but it chose to focus on that, and I would submit that
Can I ask two follow-up questions, then I'm going to let my colleagues go. I'm sorry, I didn't mean to hog all your time.
Of course, Your Honor.
You just said that there were 35 violations. Where in the record is that? How do I know that?
It's not part of the record, Your Honor.
Okay. All right. Because the disciplinary record, or whatever it might be, is not part of the record in any sense.
That's correct.
Okay. And then the second thing that I just wanted to add, these are just sort of factual questions. The district court's order directed that the probation officer file the memo regarding eligibility. And I've seen in other districts where the probation officer's eligibility memo, which is often like a chart in other districts, it is actually filed, right? So it's part of the record. And so the two questions on that. One, that wasn't done here, right? It's not, we can't find that probation officer memo anywhere in the record.
That's correct, Your Honor.
Okay. And then second, is that the practice in your district? Or is the practice typically that probation does file that? In other words, it is part of the record. Because it looks like to me the district court orders probation to file on the record what it is giving to the court, in which case the district court would assume that the probation officer actually filed this. And so I would suspect was surprised to learn that nobody knew about the disciplinary record. And so what I'm trying to figure out, is that like the norm, or do they always keep these eligibility memos secret?
I know, Your Honor, under Rule 35, in terms of recommendations for sentencing, those can be permitted to be held, not disclosed to the parties, but...
Well, but that's Rule 32, and that's during an actual sentencing. What I'm talking about are the eligibility memos by probation on First Step Back cases in your district, are they filed or not?
Your Honor, I generally can't answer because I don't have any familiarity with that other than this one case.
Okay, great. Thank you.
Thank you, Your Honor. Going back to the question of procedural reasonableness, the defendant keeps saying, or keeps arguing rather, that there is a contested calculation or a disputing calculation, and that's just not the case, Your Honors. In this case, the parties originally briefed the eligibility. The defense was put on notice about the correct calculation through the United States calculation, and waited 5 months until the district court issued its decision, and the district court didn't make any error in calculation, and I think that's important for the court to consider when focusing on the issue presented of procedural reasonableness, because there's quite a few cases that address have sent the case back for resentencing when a district court either incorrectly calculated a guideline range or failed to consider 3553A factors, like in Lancaster, but that's just not the case here. And the district court correctly calculated the guidelines. It didn't find the guidelines were mandatory, of course. It considered the factors under the sentencing guidelines, including this defendant's history and characteristics, the nature and circumstances of the offense, the need for deterrence, and of course considered the post-sentencing conduct, which is permissible under this court's recent precedent. And then when it did that, it sentenced a defendant to a within guideline range. So there's no question here that in terms of notice, the court didn't fail to put the parties on notice that it was going to vary upward or depart. And for all those reasons, I think the district court, without having had the benefit of the later decisions in Chambers, in Collington, in Concepcion, and Swain, actually did all the right things in crafting this sentence.
So, since my colleagues hadn't jumped in, I'll jump back in. I think the district court did almost everything like perfectly, except that the district court erred in relying on information from the BOP without providing notice. And maybe the district court actually told probation to provide notice and it didn't happen, but regardless, assume that that was the error, but I otherwise thought everything was done perfectly. Do you have a harmless error argument, or do you agree that that's not something that we could find harmless?
I think this court can absolutely find it as harmless error because it's not so damaging that it requires reversal. Again, I believe, or rather, the United States would argue that were this case sent back for resentencing, the district court, which which undertook procedural reasonableness and substantive reasonableness, would arrive at the same sentence given the factors it pointed out in its memorandum, opinion, and order.
Would your answer be different if the defendant on appeal was disputing part of the disciplinary record that the district court relied on? Here, in its opinion, the district court listed certain offenses and things that it found troubling about his record. And on appeal, the defendant does not contest any of that. But hypothetically, if the defendant did contest that and said, no, that's actually inaccurate, that was taken off my record, that's a misrepresentation, would your answer about harmlessness and what would happen on remand change?
I don't think it would, Your Honor, in a hypothetical sense, because, of course, this is not part of the factual record, but in thinking through what BOP procedures are in terms of maintaining and addressing disciplinary infractions, inmates have the opportunity as infractions are issued, as disciplinary reports are issued, to contest them at that point. So I believe that they would have those administrative
The
processes.
defendant says he has a right to be sentenced based on accurate information. That's a due process right, to be sentenced based on accurate information. He's not saying in front of us that any of the information was inaccurate. But if it was inaccurate, are you saying, well, he should have exhausted that by getting his BOP records corrected, and somehow we can consider it a due process violation?
I'm saying I believe that he would have had the opportunity administratively, but if there were, as the court is asking hypothetically, a situation of contested records, which is not the case here, perhaps that may lead to a different result than harmless error.
Can you give me an example of instance where we found a sentence to be procedurally unreasonable and yet have engaged in harmless error review?
Your Honor, this is embarrassing, but not off the top of my head, which I should be able to.
I'm not sure it's embarrassing because I'm not sure it's ever happened.
Thank you, Your Honor.
Can you clarify for me, where does the procedural unreasonableness come from? If Rule 32 doesn't apply in this context, which we know it doesn't, right?
That's
There's
right.
all sorts of requirements in there that don't apply. And the defendant doesn't have a due process argument because he's not contesting the accuracy of the records. What is the procedural unreasonableness that we would be looking at to determine whether it's harmless or not?
The court would be looking at, I think, just basic concepts of notice and opportunity to respond. But since that's not being contested here, and for the first issue that the defendant raises as its primary or one of its main arguments about having an opportunity to respond for the correct guideline calculation, they did in that instance as well. So I just don't think that's applicable here. If there are no further questions, the United States would respectfully request that this court affirm the lower court because the resentence it crafted was procedurally reasonable, and it considered all the necessary requirements under the precedent of Collington in order to craft a sentence that meets the ends of justice. Thank you.
Thank you, counsel. Mr. Byrne, you've got some time.
Thank you, Your Honor. Starting off with the harmless error, I'd note that the government hasn't made a harmless error argument until today. Not in the initial round of briefing, not in the supplemental briefing after Collington. So I think that is waived from that standpoint. But in talking about that error...
Can a procedural unreasonableness argument be harmless? I think the answer is yes, but I'm just...
I think the answer is yes, Your Honor. But in this case, there's been talk about the reliability of the information from BOP. Beyond that, there is the ability to place that information in context. And that's one of the reasons why I talked about the Minter case in our supplemental reply brief, because that was a case that shares some similarities with Mr. Jackson's, among the fact that he had a disciplinary record in prison and it was in front of Judge Chambers. And in that case, we were able to argue about the nature of those violations, how many of them happened in the course of a fairly lengthy term of imprisonment, and the fact that they were all dealt with administratively within the Bureau of Prisons. And Judge Chambers ultimately imposed a downward variant sentence to release Mr. Minter, but took his disciplinary record into consideration in modifying some of the conditions of supervised release. So even if all that information is accurate, and I don't have any reason to dispute it as I stand here today, there are other arguments about what that information means that might change the district court's mind as to the sentence it imposed. In the interest of full disclosure with regards to this disciplinary record, Mr. Jackson filed a pro se compassionate release motion while this appeal was pending, and in the response to that pro se motion, the government did attach a copy of the disciplinary record as it existed then. So it actually is in the record of the case, of the whole case. It was not in the record at the time Judge Chambers made his decision and we filed this appeal, but it is there now.
Can I ask you, I don't want to eat up your time with this, but I am interested in that answer to Judge Richardson's question to your colleague. Do you know if it's the practice nowadays to have these filed on the record in every case? Like, I think it is in many other districts.
I'm glad you asked that because I wanted to come back to that.
Okay, great.
I basically have been the point person in our office for handling all of these, the situations where we have all these sentence reduction proceedings, starting with the guideline modifications after the Fair Sentencing Act. And in those cases, generally what happened is the probation office prepared an amended pre-sentence, or an addendum to the pre-sentence report that included the new guideline calculations and a summary of what had been going on in prison, both good and bad. And those were disclosed to the parties, but they were not part of the record. They were not filed. So I have not seen where any of these have been filed in our district, aside from when one of the parties files it as an attachment to a memorandum or something like that.
Can you explain what you mean by that a little bit? It's disclosed to the parties but not filed.
Yes.
Meaning, like, you get it from probation?
From probation, yes, Your Honor.
They sort of send the email like they do with the original PSR to sentencing before it's entered by the court.
Yes, Your Honor, that's correct. And for a long time, pre-sentence reports were not filed in our district either. That's a fairly recent development.
So you said that with respect to the Fair Sentencing Act. Is that also true with the First Step Act? So are you similarly seeing, in other cases at least, these probation reports regarding eligibility, probation memos regarding eligibility, are they being provided to both parties even if not filed?
Not in my experience. That was the distinction I was going to make. Previously they were. In this instance, they are not.
And so are you aware of an instance in which it has been filed? I mean, it strikes me as odd here. The court orders probation to file it, which strikes me as having like a pretty defined meaning in our world, right? Which is file it. Not to be circular, but it means to like file it on the record, right? Not file it in the cabinet.
Yes,
and so, any insights you can tell me? I mean, do you interpret that differently?
I do not interpret that differently.
And so, when you, and I don't want to say you, because I understand this is not, I'm not a description of a person, but that's not a red flag that there's something that you ought to see, I take it, because from your perspective, you're not seeing these probation eligibility memos at all.
To be honest, Your Honor, I don't know that they're being done in every case the way they were with the 3582C2 proceedings. Since those were all guideline driven, I think there was a sense that that's a probation office bailiwick to a certain extent, but with the First Step Act, because it's broader than that, maybe it hasn't been, but I honestly don't know. Thank you, Your Honor.
We certainly appreciate council being here and arguing before us. As you probably know, our tradition is to come down and greet council. It's a tradition that many of us value a great deal. Unfortunately, in light of the circumstances, we have yet to resume that process, but let me assure you, we greet you and thank you and hope that the next time you're in Richmond, we get a chance to shake your hand and thank you slightly more personally.
Thank you so much for your time, Your Honors.
Thank you, Your Honors.
Our pleasure. We'll move to the second case as council gets ready. Number 21-2184, North Carolina Coastal Fisheries Reform Group versus Captain Gadsden, LLC.
Morning, Your Honor. I know we haven't been recognized yet. It would be possible to have a short bathroom break before we start?
Sure, very short. Go quickly. We'll wait right here for you.
This honorable court will take a brief recess.
So, this is the JA. This is FMP2. I don't know if I'll need any of this, probably not, but just laying out what we have at our disposal here. Absolutely. All right, let me just swamp you. Yes, I'm so sorry.
100%.
No, I'm sorry, you're fine there. Just taking all your space. Yeah. Oh, no, sorry, swamp.
You can swap all you want.
Guess I should put this guy. Pardon me.
Good morning, Your Honors.
Morning.
I am Jim
You're
Connor.
welcome to take your mask off. You don't have to, but your choice.
Thank you. That is better. I'm Jim Connor from the firm of Calhoun, Bellow, and Seacrest, representing the plaintiff appellants. In this matter, Judge Richardson, Judge Rushing, Judge Leiden, we appreciate your attention this morning. This is a case about the Clean Water Act, about the discharge of pollutants into the waters of the United States. And Your Honors, contrary to the briefing from the appellees, this is right down the middle of the fairway under the Clean Water Act. This is not an aberration. This is not stretching the act in any way. This is not finding an obscure, excuse me, I hurried to not hold the court up. This is not finding an obscure provision buried in the act and trying to expand it. This is right down the middle of the fairway. The act
Has the EPA ever granted a shrimping trawler a Clean Water Act permit?
Your Honor, the EPA has not been involved in this so far.
But I mean, ever. Has the EPA ever granted a Clean Water Act permit to a shrimping vessel?
Well, I do not know the answer to that. Would be
Are you aware of any instance in which it has?
I have not. I am not aware. I am not aware of the shrimping vessel applying for one. I am not aware of the EPA either granting or denying that application. The Clean Water Act, as Your Honors know, is set up with a citizen supervision. That's how we're here. And the courts refer to that as a provision under which citizens get to be private attorneys general. These cases usually, not always, but usually involve a situation where EPA has not previously acted. That's why the citizens spend the money, hire the lawyers, get involved, because EPA has not taken action. So this case is not exceptional in that sense, because that's why they exist, these citizen suits. And a next logical question, I don't know if it's on Your Honor's minds, but it seems to me a next logical question is, well, how'd they miss this? This seems like kind of a big deal. Who knows is one answer, but the better answer is they're a small agency. If you look at their percentage of the federal budget, it's tiny. They have a lot on their plate, lots of different laws, and they routinely miss things like this. They routinely miss areas that are fairly localized and are not factories. So the fact that EPA hasn't acted is not very telling, if you will. Now, when I say it's right down the middle of the fairway, what I'm talking about, and I don't want to be repetitive, but I just very quickly want to say that the Act prohibits the discharge of any pollutant by any person. It then defines pollutant to name several things: dredge spoil, solid waste, incinerated residue, sewage, garbage, sewage sludge, munitions, chemical waste, biological materials. And it goes on, it mentions rock, sand, cellar dirt. This is intentionally a very broad definition. Putting rocks into the water is a discharge of a pollutant. So this doesn't...
Are you still arguing, I think below the argument was that bycatch includes live fish and dead fish, that both of those are pollutants. On appeal, your briefs seem to mostly focus on dead fish, and I wanted to clarify if your argument's been refined or you're just focusing on that because it's just one example. Are you still arguing that putting live fish back in the water is a pollutant?
Judge Rushing, that's an excellent question. Thank you for asking it. We are focused on dead fish, and I looked back at our complaint because you're right, the briefing and the district court decision got off into live fish. But if you were to look at our brief paragraphs 41, 45, and 47, if I remember correctly from memory, we talk specifically about dead fish being discharged. We talk about decimation of the juvenile.
You're not arguing that live fish are a biological material?
That's correct.
Only dead fish are a biological material?
We are only arguing that the discharge of dead fish into the waters of the United States is a violation of the Clean Water Act.
How do I make that decision? It seems like such a broad term.
Yeah, that's a good point. And we certainly know that live fish in some instances have been found to be biological materials. And honestly, we'd be perfectly happy with the decision from this court that said both dead and live. But what we're concerned about is the dead fish. They're the ones that actually pollute the water in a common sense kind of way. Live fish don't pollute the water in a common sense kind of way. But we have U.S. Perg versus Atlantic Salmon from the District Court of Maine. It's not binding on this court, obviously, but it says the release of non-native salmon species is a discharge of biological material. So it's a well-placed question. Our concern, and what we're asking this court specifically for, is a ruling that the discharge of thousands of tons of dead fish into our waters, specifically Pamlico Sound, but any of the waters of the United States, is a violation of the Clean Water Act.
Can you help me understand that a little bit? Because I think Judge Rushing's, I too think it was an excellent question.
Thank you.
So,
I do too.
but I have a little bit of hard time understanding that, because you began by saying that the word pollutant is defined in the statute to mean, not to include, but to mean a whole list of things, including rocks and heat and biological material. And what I'm having a little bit of a hard time understanding is, what about killing a fish moves it from non-biological material to biological material, right? So it strikes me that it's biological material when it's alive and it's biological material when it's dead, if I apply the natural understanding of that phrase in isolation. And so you're trying to suggest to me that I should read it more narrowly, but help me understand why I should do that.
Well, I'll be frank and say this is a line of questioning I was not expecting. I was expecting to be questioned about why I wanted it to be so broad. But yes, you're exactly right, Judge Richardson, that dead fish and live fish are both, in the common understanding of things, biological materials. Again, our focus is on the dead ones, but we have no objection to the court finding that it includes both live and dead.
So how about, can you talk to me a minute about heat as well? So if I run an outboard motor on my John boat in a river or estuary or the ocean, by definition, that outboard's putting heat off. Is that a discharge of a pollutant into the water under your understanding of heat?
Well, great question. Honestly, I haven't thought about the heat part so much, but what that goes to generally is the principle that's true in all of the environmental laws, and for better or for worse, it's what I've been doing for 37 years is environmental law.
That's why we're asking you these questions.
These laws are broadly worded, and they include rocks and sand. Well, is a kid standing on the shore throwing a rock in the water? Is somebody going to swoop in from EPA and snatch him up and make him get a permit? No. And that's the way
But your view is they could, right? So when my 9-year-old girl skips a water across the pond, not the pond, maybe that's not navigable, but if I do it at the ocean, at least, that the EPA indeed could cite her for violating the Clean Water Act because she is discharging a rock into the water by skipping it across, because it stops eventually. She can't get it all the way across the ocean, it goes in.
That's right. That's a great question, and again goes to the very fundamental nature of how these laws work.
But it just works that way because your point is the EPA, in its sole discretion, just gets to decide whether my daughter walks free or not. It's just up to the EPA administrator just gets to decide, hey, Landry, like, you're good or you're not good, right? Like, they just get that full discretion, and that's the reading that you're putting forward. Or, to take the same example, if she baits a hook with a worm and throws it in the water, right? That, too, is a discharge of a biological material into the waters.
Well, Your Honor, it's both true, what you're saying, and a good illustration, again, of how these laws work, because there's no question that a rock is a rock. I mean, it says rocks. And so if your daughter throws that rock, that is a rock. There's no ambiguity there. And yet, that's not something EPA is worried about. The administrator doesn't.
Well, they might not be worried about it today, but, you know, when they find out that, you know, my daughter's doing it, they might become worried about it, and there's nothing that you can do about it, right? So if I ride a boat, if I'm in a boat at all, inboard or outboard, I'm putting heat out, right? If I skip a rock, if I fish, if I crab, if I'm the South Carolina Department of Natural Resources and I stock a river with new trout, putting biological material in, all of those things, in your view, require a permit or subject yourselves to sanction.
No, sir. None of those things require a permit, and it's because that's the way the statute's set up. That's what Congress put in front of us, is the Clean Water Act. with these
Wait,
broad-
none of those require a permit?
I may have missed one, Your Honor, but certainly you running your outboard engine off your
I'm putting heat into the navigable waters, right? My daughter is putting a rock into the navigable waters. It's adding to the navigable waters. She picked it up in the mountains, she carried it down to the coastline, and she tossed it in.
Yes, sir. Yes, sir. I understand the hypothetical. It is within EPA's discretion, as you said earlier, to decide where they draw these lines. As we know, there have been court cases where their decision to draw a line here or there is challenged. Incidental fallback is a great example of that, where they did not have an exception for incidental fallback, and the court said they had to, the Tulloch case. So they had to go back and revise the rule and make an exception or an exemption for incidental fallback. The practical way that this works, I mean, here in a courtroom, we can get up in our heads and think, well, gosh, a rock or an outboard motor. And it's true. You're absolutely right. But in the real world, that's not something anybody's concerned about. My sons throw rocks. Well, they're grown now, but they used to throw rocks in the water. I have a boat. It discharges heat into the water. I don't
Can you
drive
spend
around
a few
worried about
minutes
that.
in light of this discussion, taking this discussion into context, and talk to me a little bit about why you think the major questions doctrine doesn't apply under West Virginia versus EPA?
Yes, sir. Yes, sir. The major questions doctrine doesn't apply for a couple of reasons. First, this is not on the level that the Supreme Court was talking about in West Virginia.
That is every boater, fisherman, rock skipper that exists in America. Like, that's not broad enough for you.
Well, let me move back to what this case is actually about, which is dead fish being discharged in large volumes into the water. That's what this case is about. Now, we may all have a quarrel with the Clean Water Act and what Congress did with the Clean Water Act when it said rocks, sand, and all these things that can be interpreted that broadly. And in fact, I don't know how else you interpret rocks. Rock's a rock, like I said earlier.
Hasn't the Supreme Court told us? I mean, in Train, the Supreme Court refused to interpret pollutant to the outer boundaries of the word. They've told us that it requires looking not just at the dictionary, right?
Well, not just the dictionary, but what it also requires from EPA and what it has done since 1972, what's that, 50 years, is to look at situations that need enforcement and situations that don't.
Well, that's an argument against you, isn't it? They've decided that shrimp trawlers don't need enforcement.
Well, we don't know that. What we know is they haven't done anything. Whether anybody in the EPA...
That's cold comfort to Judge Richardson's daughter. They haven't done anything in her case either, but they might.
Well, may I talk for a minute about the major questions doctrine? So the Supreme Court, in talking about what they were looking at, said early on that EPA's own modeling concluded that the rule would entail billions of dollars in compliance costs, require the retirement of dozens of coal-fired plants, and eliminate tens of thousands of jobs across various sectors. It would reduce a study by the Energy Information Administration found that it would reduce the gross domestic product by at least $1 trillion. It goes on to talk about an agency decision of vast economic and political significance. These are the kinds of things it was looking at in major questions. When it just talks about major questions, something that's going to be an upheaval to the entire U.S. economy, like the Clean Power Act arguably would have been. I mean, I think whether you think of the Clean Power Act was good or bad, everyone would agree it was going to be a major upheaval to the entire economy. Every state, Iowa, Minnesota, every state was going to be affected by it. This case, we're talking, it's very important to us, but we're talking about estuarine waters along the coast of basically North and South Carolina.
But if you're right, it applies to all commercial fishing operations, right? Even if you adopted some version that just limited it to dead fish, it's all commercial fishing operations, right? And the point is that no commercial fishing operation can both comply with the Clean Water Act and the state requirements to return, and state and federal requirements to return bycatch to the water. So it says you cannot engage in commercial fishing.
Your Honor, thank you for the question. I do disagree with that statement.
All right, help me understand why.
It does not apply to all commercial fishing because most fishing does not involve the killing of great quantities of other fish they were not after. Now, if you're after the fish, of course they die and you take them to the market and they get sold and people eat
It's
them.
only because it's great quantities. So if I have any bycatch, so if I'm a crabber and as a result some extra fish die in the crab traps, right? Or I'm a longline fisher and I catch some fish that I don't want to catch and they perish as a result, right? Or any other kind of trawler that ends up in the same world. Like, I can't figure out what example of commercial fishing doesn't result in the incidental kill of some fish that are then returned to the water.
I understand your point, Your Honor. And I think that a lot of this line of questioning goes to, was the Clean Water Act a good law or not? Because there is no question what the list of pollutants is. And there is no question, as Your Honor has pointed out, that if it's heat, yeah, there's some heat coming out of an outboard motor. If it's rocks, yeah, my daughter throws rocks in the water. That's the way the act is structured. That's what Congress gave us. If we don't like it, we can get elected to Congress and change it.
But
that's
Congress
what
also gave us laws that say the state has the right to manage the natural resources, including fish and shrimp, in its waters. That's the Submerged Lands Act. But Congress also gave us the Magnuson-Stevens Act, right, which has a long series of requirements, and that the state has implemented its own requirements. So we're not just talking about one law. We're talking about this conflict that happens if we read the Clean Water Act as broadly as you're asking us to. We have to look at everything that Congress has said about this area, and it seems to suggest that they don't intend to cover these fish under the Clean Water Act, but instead under different acts of Congress.
Thank you, Judge Rushing. And that is something I wanted to talk about because the appellees spend much of their briefing on this argument that there's other fishing laws that are somehow in conflict or preempt the Clean Water Act or something like that. My colleague Shannon Arata, who wasn't able to be here today, had a great line. She said there are a lot of strong statements in that brief, but not much law. And that's correct, yeah. The Magnuson-Stevens Act says some things, some other acts say some things, but none of those acts, despite language in the brief, they have shown us no statute or regulation, present or past, that tells us that it is a traditional role of the fisheries management laws to say what happens in terms of discarding pollutants back into the water, or if we want to narrow it down, what happens with regard to discarding dead fish in large quantities back into the water. And I do keep saying large quantities, and that's on purpose, because what will happen here is that EPA, if we get the decision we're looking for, is that EPA will step in then and say, okay, all right, we get it. Fourth Circuit's told us what we have to do. We're going to set up a permitting system for this. We're going to set de minimis exemptions. We may issue some general permits that say everybody who's doing commercial fishing and has less than 5,000 pounds of dead fish, you're good. You've got a general permit. You don't have to do anything else. That's what they do. That's what they do with all of these categories of pollutants. That's how the Clean Water Act actually works.
Thank you, Counsel. We've got some time for you on reply. We're happy to hear from you.
Good morning, and may it please the court. Congress does not hide whales in fish bowls. And so the district court was right that by including biological materials in a list of pollutants, Congress did not regulate bycatch under the Clean Water Act. And Congress did not thus outlaw the shrimping and fishing industries in which bycatch is inevitable. And Congress didn't hide that sea change from the EPA and everyone else for the last 50 years. Today, I'd like to address three specific reasons why the Clean Water Act does not regulate bycatch. And first, I'll start with the major questions doctrine, which seems to be the most timely reason for affirming the district court. And that doctrine gives us profound reason for skepticism that 50 years ago, Congress actually put the EPA in charge of regulating bycatch as part of fisheries management. And this case has all the hallmarks of the major questions doctrine, as the Supreme Court just applied it in West Virginia. So first, there have been decades of EPA silence, 50 years where the EPA has not sought to regulate bycatch, has not sought to regulate fisheries management, which is precisely the upshot of what the plaintiff's theory would do here. Second, at best, there's vague text in the Clean Water Act that would support the application of the power that the plaintiffs want to give the EPA here. Third, the technical and policy expertise that is necessary to manage fisheries, to determine how much bycatch is or is not appropriate, is beyond the EPA's ken. They've never claimed that they have the expertise in fisheries management that would be needed to decide how much bycatch is too much, how much is enough for one fishery versus another fishery. And last, indeed, this would be an existential threat to industry. As to commercial shrimping, you don't have to take my word for it, because that's precisely the relief that the plaintiffs are asking. On pages 30 and 31 of the JA, they ask for an injunction that would, in effect and in practice, shut us down. But Judge Richardson, as you recognized, it's not just commercial shrimpers that would be affected by this, commercial fishermen too. There's bycatch in just about any fishery. You never know what you're gonna pull up when you go fishing. But beyond commercial shrimping and commercial fishing, it's not at all clear to me why my friend's own clients would be safe from the rule that he wants, why recreational fishermen would be safe. Because they too use bait, which on their theory is the discharge of a biological material. They use chum to attract fish. They catch undersized fish and fish of undesired species that are returned to the waters, alive sometimes and dead sometimes. So I understood him to say that it's within the EPA's discretion where to draw the line of which bycatch is too much and which is fine. But that's not something that Congress put within the EPA's discretion. There is one major difference between this case and West Virginia, of course, and that is that in West Virginia, it was the EPA that the Supreme Court held was trying to aggrandize its own authority. But here, it is plaintiffs who seek to force that authority on EPA that in 50 years has never tried to exercise it. So briefly, two more reasons why the district court should be affirmed. First is the statutory federalism embodied in the Clean Water Act, and Section 1370 gives us a rule of construction for the Clean Water Act in particular that's really dispositive here. And that rule says that absent a clear statement, nothing in the Clean Water Act shall be construed as impairing or in any manner affecting any right or jurisdiction of the states over their waters. And Judge Rushing, you were exactly right. The Submerged Lands Act gives vested title and power to the states to manage and use the natural resources in the lands underneath their navigable waters and those navigable waters themselves, and in particular defines those natural resources as fish and shrimp as relevant here. And for its part, North Carolina does unambiguously exercise that jurisdiction. The regulations dealing with fisheries management in North Carolina are extensive. The DMF, the Division of Marine Fisheries, has created extensive records of what they're doing and why in the amendments to their shrimp fisheries management plans. And so it's implausible that Congress reversed its longstanding policy of recognizing state jurisdiction over those waters, over those fisheries in those waters, through a vague reference to biological materials in the Clean Water Act. And last, there would be interference with the bycatch mitigation provisions of the Magnuson-Stevens Act if the district court were reversed.
Can you, all right, I wanted to get to the third one.
Sure.
Can you go back on the major questions doctrine? I mean, one of the things that the court seems to do in West Virginia versus EPA is determine, like, is there a plausible textual understanding the other way? Right, that if there's clarity, another way of saying this is you can't have a major questions case if the statute itself is clear that it is providing that authority to the agency, right? And so in West Virginia v. EPA, the court goes through and explains why there's a lack of clarity there, and that is what ultimately brings it within the doctrine. Can you help me understand why biological materials lacks that kind of clarity? I mean, it seems to me to be like actually somewhat of a quite clear term and extraordinarily broad. And so just from the textual understanding of the phrase, why, even if I thought every other aspect of the major question doctrine applied, why wouldn't I say, as your colleague suggests, maybe this is terrible policy, but this happens to be an instance in which the law is like quite clear that biological materials means like things that are effectively made of carbon, if we want to go too far down that road. But you get the idea.
Two reasons, Your Honor. One is that we can do what the Ninth Circuit did in the Hammersley case, which is look at the Noscitura Soki East canon and look at some of the other items in that list. And what the Ninth
So
Circuit...
help me understand. So can I stop you there? Because I find that one interesting too. The court there, when it goes through and describes, instead of saying that pollutant means these things, it repeatedly describes it as includes, right? As if it's a list of examples, right? It says it's an illustrative list of examples. But I don't read the statute that way. It doesn't say pollutants includes sand, rock, and biological materials, right? It says it means that. And so it strikes me that the analysis of the Ninth Circuit changes the definitional to an illustrative example, and in doing so, like that's how it makes its canon work. What am I missing that? I mean, do you understand what I'm saying?
I think I do, Your Honor, but frankly, given the number and breadth of things in that list, I'm not sure there's a lot of daylight between means and includes in this particular context. But
But if it says includes, right? So one way of thinking about that, I don't want to belabor this, but if it said pollutant includes these things, well, then we still are looking at the word pollutant to provide some substance, right? Because that means that the pollutant, these are examples of pollutant, but they don't define pollutant. And so we would look at the meaning of pollutant, the ordinary understanding of pollutant. But we don't look at the ordinary understanding of a word where it is specifically defined by statute. And here, instead of saying these are examples, it says that's what it is. It means biological materials. It's not an example of pollutant. Pollutant means biological material.
Right, Your Honor. I think either way, we're trying to ascertain the meaning of biological materials, and I don't understand the plaintiffs to allege that there is some, even if it were pollutants includes these things, that there's a freestanding understanding of pollutant that would apply here. The argument, as I understand it, is that these bycatch materials are biological materials, and that's why they're caught up in the Clean Water Act. But as the Ninth Circuit said in Hammersley, those surrounding terms tend to deal with the byproduct of an industrial process. And so one reason that you would find some ambiguity in the statute, whether or not you need that for the major questions doctrine, you would find ambiguity because biological materials shouldn't just be anything that happens to be there, a live fish, a dead fish. It should be the byproduct of an industrial process. So that's one answer. But the second answer looks at Section 1328 of the Clean Water Act, which addresses aquaculture in particular. So when Congress wanted to regulate fish under the Clean Water Act, it knew how to do that, and it did that in Section 1328. And under the plaintiff's theory, Section 1328 would be entirely superfluous because fish would be regulated under biological materials already. And we know that's not the case because Congress felt it necessary to add that specific section in 1328.
But I'm not familiar with 1328. Does 1328 prohibit the discharge of fish into the waters of the United States?
No, it gives the EPA specific authority to regulate aquaculture.
Right, but that's only if you're farming fish, right?
Correct, exactly.
So wouldn't apply in the scenario we've got here. Nobody's suggesting this is about farming fish. So I guess I'm having a little trouble understanding why fish farming would render a prohibition on discharging fish at all into the waters. Like those just seem like totally different questions, right? Like if you farm fish, fine, this is how you do it. But what you can't do is let them out their cage.
But the way that aquaculture, fish farming, generally works, Your Honor, is that those fish are placed into the waters so that they can grow and be fed there. And so Congress does know how to address the regulation of putting fish into water when it wants to, and it did that in Section 1328. And my point is only that it hasn't done anything remotely like that here. And so if I may, Your Honor, I'll just briefly conclude with the Magnuson-Stevens Act, which does tell fisheries managers to minimize bycatch and the resulting mortality, but only to the extent practicable. Congress made that policy choice that it's not something that they wanted to eliminate altogether because, as Your Honor pointed out, bycatch is inevitable in just about any fishery. And so Congress did not take the extraordinary step of eliminating all bycatch or requiring fisheries managers to eliminate all of it. But that provision, that directive to mitigate bycatch without necessarily eliminating it, that would be superfluous if Congress had already decided in 1972 that without a permit, bycatch is completely illegal already.
So help me understand that one too. I'm sorry. Because you might regulate bycatch even for permitted vessels, I think would be your colleague's argument, right? That like you could both fall under that act and the regulations that apply and require, in theory, a Clean Water Act permit to engage in fishing at all. You just need two different ones.
In theory, Your Honor, but in 1996, when Congress enacted the Sustainable Fisheries Act, which amended the MSA, Congress, there were no permits then. There still are no permits now from the EPA covering bycatch. So if Congress is going to say you need to minimize bycatch, on the plaintiff's theory, what Congress did in 1996 to the Magnuson-Stevens Act was entirely superfluous because it was already illegal, period. And as Judge Rushing pointed out, this is exactly the scenario that the Supreme Court addressed in Train, where the 10th Circuit said radioactive materials means radioactive materials. And the Supreme Court reversed because it wasn't going to interpret pollutant in the Clean Water Act to encroach on other targeted regulatory schemes. There, under the Atomic Energy Act, here, under the Magnuson-Stevens Act, and in the many, many state fishery management regulation establishments. So if the court has no further questions, we would ask you to affirm the dismissal of the complaint.
Since I've got some time with you, we've talked mostly about biological materials. Can you talk for a minute, if you can, about discharge and whether this counts as a discharge? In particular, I'm interested if you've got thoughts on how our decision in Deaton is affected by LA County flood and the line of cases that follow it.
Yeah, so my primary answer, Your Honor, would be to repeat most of what I just said, that both as a major question and under Section 1370 and the Magnuson-Stevens Act, this is a case about how to manage fishery resources. And so for all those same reasons that Congress didn't regulate bycatch using this reference to biological materials, Congress didn't outlaw or put EPA in charge of permitting the use of specific fish tackle in the same statute. So that's our primary response for those. I mean, the district court was also correct that as a technical matter, there is a Army Corps of Engineers regulation that says this section does not apply to incidental fallback, and that's correct. But I think the easiest way to dispose of it is using the same analysis that would apply to the bycatch issue as well.
Okay.
Thank you, Your Honor.
So, all right, sorry, last thing, since you're here. No, I'm good. Thank you.
Thank you, Your Honors.
Appreciate you, counsel. Mr. Connor, we've got a few more minutes for you.
Yes, sir. Thank you. So my learned colleague and his team go off the track in a couple of ways. One is to say that these fisheries laws have occupied the space. As I started to say earlier, in their brief, although there are a lot of strong statements about that, they provided us with not a single citation to any law or regulation in the Magnuson-Stevens Act, any state laws, anywhere else that regulates how you put dead fish back in the water, whether you can do it, how much of it you can do, how you do it. None of that. It's not regulated. It's not a traditional fisheries management issue. Fisheries management is about what can you catch and what can you keep if you catch it. How long does it have to be? How heavy does it have to be? How many of them can you have per day?
Are you familiar with the turtle excluders?
I am.
Is that part of fisheries management? Right? I mean, it strikes me that it is, right? Because the whole point is, it's about not catching turtles, right? So,
I guess I was getting too technical. My background's in biology. A turtle's not a fish, so I would say it's not fisheries management, but it certainly is management of how they're fishing, yes.
right, the point is, it's not just about what they're bringing in, it's also about the manner in which they're engaging.
In which they're catching things. We're not talking about that.
Turtles is not catching things,
Or not catching things. And that's
like bycatch.
Yes, sir, and thank you for that, because that's the other point, the next point I wanted to make about my learned colleagues' statements and briefing. We're not asking you to regulate bycatch. We're not asking you to say, right now they're catching 34 million pounds of bycatch, they can only catch 20 million, or 0, or any other number. Under the Clean Water Act, they can catch as many bycatch as they want, because that's not what the Clean Water Act's about. It is not a fisheries management statute, and we're not arguing that it is. They can catch things the way they want to, as long as they're in compliance with the fisheries laws, in the season they want to, and in the amounts they want to, as long as they're in compliance with the fisheries management laws. This is not a fisheries management case.
Didn't you initially sue the Division of Marine Fisheries, the North Carolina Division of Marine Fisheries?
We did and thought better of it. Yes, Your Honor.
But you argue now that they so don't occupy the space, this just does not apply, and yet that was who you initially sued.
It was one of the entities we initially sued, yes, ma'am. And it was about the public trust doctrine. If I remember, it's been a couple years ago, and I haven't thought about it recently, but we were talking specifically about the public trust doctrine. There were some negative decisions that had come down recently. We dismissed them for that reason. But yes, the point remains that this is not a fisheries management case. We're not asking this court to rule on anything about how fishing is done, about how much bycatch there can be. What we're talking about is the Clean Water Act, which talks about putting dead fish in the water. And I want to go back to one of the early questions, Judge Rushing, I think it was you.
I don't want to take you off track, but you said you're not making any argument about how fishing is done.
Yes, ma'am.
But your dredging argument is about how fishing is done, right? Now I know that's a separate argument, but you're raising that on appeal. That is an argument about trawling, right, and how it disturbs the seabed.
Sure, that's a great point, thank you. And I was focused on the bycatch disposal issue, the dead fish disposal issue. But you're right, the dredging is a question of how it's done, because dredging stirs up the sediment. We believe under this court's previous decision in Deaton, that's clearly a violation, that is. You'll remember, of course, that Deaton says in digging a ditch, even though the dirt you dig up is the same dirt you're putting back down, that dirt is transformed by being dug from dirt into a pollutant. I've got a great quote to read you, but I don't have a lot of time. So
what is the harm that is caused by the resuspension of the sediment? Your complaint has a lot of, it talks about harm caused by the physical act of trawling, pulling something along, but your argument has to be that the sediment itself is causing a harm if you're going to make a dredging claim.
Yes.
What is the harm? Where in your complaint is the harm that the sediment is causing to aquatic function?
Yes, Your Honor. It's a good question, as always. And we do allege that in the complaint. Our reply brief goes through paragraph by paragraph where that is, and I'm sorry I don't have it.
I read those, and it looked like all of the harm was from the trawling, disturbing habitats, et cetera. It wasn't harm from the sediment being
So what happens
resuspended.
with the sediment is that it does get resuspended, and then it falls back out in a different place. When it falls back out in a different place, it chokes. I'm a scuba diver. I don't know if y'all have done that, but there's lots of things that live in little holes under the bottom of the ocean, and those holes get filled up by the sediment falling down. Seagrass gets covered with it, like in the U.S. versus CC case, or MCC case.
And is that in your complaint?
I probably didn't say it that specifically, Your Honor. So, I want to go back though to this, and I don't want to hit it too hard, but I've got very little time. We're not talking about regulating fisheries. We're not talking about regulating how much bycatch we can get. What we're talking about is a down the middle of the fairway Clean Water Act issue, which is, can they put dead fish back in the water? Those fish, may I have just a few seconds?
Sure.
The fish have been transformed by a human process. That's Hammersley language, as y'all are familiar. And that, I think, goes back to the original question about live fish versus dead fish. Live fish, they've been pulled up and then they've been put back. I don't think that's much of a transformation by a human process. Pulling fish out of the water or other marine organisms out of the water and letting them die or killing them, that's about as transformative as you can get. You go from alive to dead, and that's done by humans. That's a transformative human process. And when that goes back in, that's a pollutant under the clear language of the Clean Water Act.
Thank you, Counsel. As you probably well know, we normally come down and we value the opportunity to shake your hand and say hello in a little more personal level. We obviously have not gotten back to that tradition. We hope to soon, and we hope to see you back here, but we certainly appreciate your help with this case today.
Thank you very much.
Thank you, Your Honor.
We will proceed to the next 2130, Bygum versus the City of Montgomery. Mr. Taylor, we'll be happy to hear from you.
Thank you, Your Honor, and may it please the court. My name is Michael Taylor on behalf of Petitioner Police Officer Roger King. The issue before the court is whether it is reasonable for a police officer to use deadly force on an individual who is aggressively reaching towards his waistband, indicative of the presence of a weapon, while making threats and being non-compliant. The answer to this is yes. These are undisputed facts that the trial court found. Despite this, the trial court denied qualified immunity and decided that this is an issue that should go to the jury. This constitutes error for two reasons. The first reason is that the trial court erred in determining that Mr. Young was not an imminent threat to harm to Officer King. Secondly, the trial court erred in finding that the law at issue that governs this specific fact pattern was clearly established. In looking at the first argument, that the trial court erred in its determination that Mr. Young was not an imminent threat of harm to Officer King, there's two alternative bases for why the trial court erred with respect to this. The first is that the trial court erred by relying upon facts that were blatantly contradicted by the record to reach this conclusions. The second reason is that even if you take the facts that the court relied upon, which are blatantly contradicted by the record, the court failed to look at the totality of the circumstance facing Officer King in denying qualified immunity. Looking at the facts that were blatantly contradicted by the record, the court found that Mr. Young was stationary or standing still at the time that Officer King used force. This fact was admitted in the response brief by the respondent as being wrong. The trial court did err with respect to the fact that Mr. Young was stationary at this time. There's no evidence in the record that Mr. Young was stationary. Officer King testified that Mr. Young was advancing towards him. The expert hired by the plaintiff to recreate the accident could not rule out whether Mr. Young was moving at the time of the shooting, could only identify that he was not running at the time of the shooting. So despite the fact that the only evidence in the record is that Mr. Young was advancing towards Mr. King, or towards Officer King.
Why is there evidence in the record of that? Help me understand that, right? Because your client says he was charging at me, and this is at this stage. I'm not saying there's not evidence from which a jury can, but at this stage, your client says he was charging at me, and he described what charging meant to be running. In his, I'm just reading his words, right? He used the words running when asked what charging means. At different points, he used different words, but at least once he used the word running. And the expert says, no, that's not true, right? And then your client says he was 8 to 10 feet away from me when I shot him. And the expert says, no, not true. And those may be really good jury arguments, but don't I have to take both of those in the light against you, which means that the officer is not telling the truth about the distance or the mode or manner in which the defendant was moving at the time he was shot? And if that's true, then I'm having a really hard time. I get your other arguments, but I have a really hard time seeing how you get very far given that scenario.
Understand, Your Honor. Well, here's where we're at is we know that the undisputed record is that there was movement by the victim, Mr. Young, because their expert said, I cannot rule out that he was moving forward or backwards.
But can't rule it out is not the same as showing that it happened. I get you want to say that. I understand, and you say that they conceded. I don't think they conceded at all. But my point is, go back to like what is happening, right? Your client said, he's running at me and I shoot him when he's 8 to 10 feet away. And the forensic evidence, at least as this expert suggests, is that that was false.
Well, Your Honor, the forensic evidence with the 8 to 10 feet, that the forensic evidence is, or the expert's opinion on the forensic evidence on 8 to 10 feet is, well, that was not true. The forensic evidence on whether he was moving at the time, don't know.
No, he said he's not running.
Correct, Your Honor, but he also said that he was not moving. But irrespective of the speed upon which that...
All of these are arguments you can make to the jury, but what I'm trying to get at, and maybe and I don't want to push it too hard, because sometimes the answer is you got a client and there's just nothing you can do with it, right? But those two things, I'm having a hard time. So hypothetically, if I found on this record at this stage of the proceeding that your client falsely claimed he was 8 to 10 feet away and falsely claimed that he was running toward him, and instead he was not running toward him, whatever other movements he was doing, and was 50 feet away, how could I possibly reverse the district court here?
Because that fails to take into the other actions by Mr. Young that were going on, the victim at the time, which the most aggressive action, which the trial court described as an aggressive action of grabbing towards his waistband, which is indicative of grabbing towards a weapon. So even if the officer was 50 feet away at the time that Mr. Young makes this action.
But Officer King didn't describe it that way. Officer King, he said there was, he was flailing his shirt. I didn't see anything, so I didn't think much of it. He did mention at one point, I drew my weapon because, you never know, he might have something. But that's not when he shot. He drew his weapon and he had his weapon out for a while. Then come the shots, and I didn't see any testimony in the record that at the moment he shot, he thought the victim was reaching for something. He said he has testimony that he could have had something. You never know. You can't rule it out. That's all of his testimony after the fact about what might have happened. But I didn't see any testimony that's as clear as what you're trying to say now.
Well, and that may be Fair, Your Honor, but I think if you look though, and you have, so what is happening is we have statements that are made after the shooting that are jumbled by Officer King, that are jumbled. They're not clear. It's not a deposition at that time where they're trying to pin him down on specific details. He's just in an emotional state giving a statement that's not being clarified.
Right, and one version of those may be more correct than another version. That's absolutely right. But at this stage, don't we have to take the facts in the light most favorable to the victim?
You do, Your Honor, but I don't think the facts create per se an inconsistency. There's just a lack of clarity in his statement upon which the plaintiffs want to rely upon, and then those issues get clarified in his deposition, and he clarifies what he means by these things. It's a lack of clarity.
Maybe that's an argument you can make to a jury, right? No, he was just really upset, and when he changed his story, it was just a clarification. It wasn't an inconsistency. Those are like totally reasonable arguments, and they might well be right. But how do we adopt those instead of drawing the inference the other way, which is he changed his story to try to match it up with what had happened?
Well, again, the evidence, though, that they try to use to show that, geez, there's all these inconsistencies is forensic evidence by an expert, that even the forensic evidence gets changed in the deposition about where the movements are, the distances upon which, where the shootings occurred. The 50 feet, for example, is another issue upon which that their own expert, upon deposition questioning, hey, if Officer King said he was backpedaling at the time this occurred, does that change the direction upon which the calculation? And he said unequivocally, yes, it does. And so that does.
The problem is you got an if in that sentence, right? And the record doesn't actually show that he was backpedaling when he fired.
Actually, Your Honor, I disagree.
I understand that you disagree, and I've read where you're reading, but if I'm reading the information in the light most favorable to the decedent, right, I don't read those sections as saying when he fired, he was backpedaling. It does say that he backpedaled, but it does not say that when he fired, he was backpedaling. I don't read them that way, at least given the context in which we have to take them against you to the extent reasonable.
Your Honor, if I'm not mistaken, he, in both his statement to the investigator afterwards and to the in the deposition, he testifies he was backpedaling at the time that he was shooting, and there, I don't think there's even a dispute about that, because the bullet casings show movement on the part of Officer King, and his test. I mean, so with that said, I mean, it's kind of, this is a situation where there's only one inference that can be made. The bullet casing.
There's not a follow-up question in that deposition. The question is, would it change your opinion about the direction if he were backpedaling? Yes. But the obvious question next is, what would it be? Would you agree with the decedent then? But there's no follow-up to tell me, oh, well, the answer would be completely different, and I have to, even construing it in favor of the decedent, the officer is correct.
I think in the question it says, would it change your opinion as to whether he was moving forward in an east to west direction versus a west? And he said yes, and so.
Right. So which direction?
Yes, and I think that was in the questioning. But with all of that said, these are all the factual disputes that may or may not be at issue. But if you go to our other argument, which is the law at issue has to be clearly established at the time upon which the officer engaged in these acts. So even if you want to have these factual discrepancies, which, by the way, this court has affirmed of qualified immunity when there has been certain factual discrepancies involving whether a person was stumbling or running, whether a person had a knife in their hand or not had a knife. Sigmund v. City of Chapel Hill or Town of Chapel Hill case is almost exactly on point here, where there was a factual dispute as to whether the suspect at that time was advancing towards an officer, or whether he had his hands up in surrender. And the officers testified that it looked like he was moving towards them, and that's why they fired their weapon. And bystanders said, well, he had his arms up in surrender. And the Fourth Circuit said, those disputes do not matter. It's the officer perception at the time of the shooting that we have to look at as to what occurred. So even if there is a factual dispute over was he charging or was he advancing forward at a speed less than running, we have to look at the officer's perception at the time. We don't apply 20/20 hindsight with respect to that. And the Sigmund v. Chapel Hill case is almost directly on point. And in that case, the court affirmed and said qualified immunity in this case. Now, the cases that were relied upon by the district court are all not miss key facts that were present here, namely the indication of a weapon. The fact is that Officer King repeatedly said in his statement and in his deposition, yeah, I did not see a weapon. I didn't rule it out. I didn't rule it out. And the fact of the matter is, Mr. Young had a weapon. He ended up having a knife on him. So so looking at the totality of the circumstances, even if he was standing still at 50 feet away, even if he was not moving and he was stationary, the fact going to a weapon indicates to the officer in his perception, he may have a weapon, I need to protect myself. And that's what the case law says. It's not a suicide
Can
pact.
you help me just for the record site that you would like us to look at? Because I see the repeated reference to when he shot the decedent, that the decedent was charging at him. But at that moment, what is the record site that he was reaching into his waist for a weapon, that was the perception of this officer?
Okay, so, and by the way, the district court accepted that.
I just want the record site. All I'm looking for is, I just want to see what it is that I'm reading, that at that moment in time, the officer perceived that he was reaching for a weapon.
I apologize, Your Honor, I should have flagged it better, but I know it's in.
It's okay. You can bring it up on rebuttal. That'll be okay. But if you don't mind providing that when you come back up for a response, I'd appreciate it.
Absolutely, Your Honor. Thank you. And that's, I think, basically my time. We request that you reverse the trial court's ruling, enter an order affirming or granting summary qualified immunity. Thank you, Your Honor.
Mr. New, we're happy to hear from you.
May it please the court, Your Honors. My name is Stephen New. It's my pleasure and privilege to be here today representing the family of Eric Mitchell Young. This honorable court should affirm the district court's denial of summary judgment in this case. There was no reasonable, objective reason for Officer King to believe that Mr. Young posed an immediate threat of serious bodily harm to him. The appellant's claims are unsupported by the record and should not be condoned by this court. The District Court for the Southern District of West Virginia correctly denied the appellant's motion for summary judgment seeking qualified immunity. Judge Copenhaver, applying the well-established facts in this record as he was required to in the light most favorable to the non-moving party, and the district court properly found that questions of fact exist and found that Officer King's deadly actions were objectively unreasonable. The force used excessive under Graham v. Connor. And the district court also found that Mr. Young's Fourth Amendment rights plainly violated by Officer King and clearly established at the time of the shooting in the early morning hours of February 11, 2019, in the streets of Montgomery, West Virginia. Of course, the standard of review in this case is a de novo standard of review. And as Judge Richardson has already pointed out, that courts must neither resolve disputed facts, nor weigh the evidence, nor make determinations of credibility. Decades of case precedent The party opposing the motion is entitled to have his or her version of the facts accepted as true, and moreover, to have all internal conflicts resolved in his or her favor. And indeed, what's happened here is that the police officer has killed the only other potential witness to the shooting, and courts have been cautioned to avoid simply accepting officer testimony as true. With respect to the facts in this case, Judge Copenhaver sets forth the facts at pages 2 through 10 of the order denying summary judgment, document 142. And I'd like to just touch on some of those facts in follow-up to some of the questions by this court. And the citation asked for appears at page 3 of the memorandum opinion. And Judge Copenhaver stated, in addition, Young repeatedly flailed his arms and his shirt, which Officer King testified caused him to suspect aggression and the potential that Young could be reaching for a firearm in his waistband. That's Officer King's statement in the hours after the shooting and his deposition testimony at pages 52 and 61. The court goes on, but Officer King never saw a weapon in Young's waistband and never saw Young wield a weapon. In viewing the facts in the light most favorable to the non-moving party here, the court did not, as the appellant suggests, blatantly disregard facts that were blatantly contradicted in the record. The court found 7 facts in its decision, which a jury could readily conclude violated Mr. Young's rights under the Fourth Amendment. Number 1, that Officer King was initially 50 feet away from Mr. Young when he opened fire. Number 2, Officer King then fired 4 more rounds as Mr. Young was falling to the ground, firing the last bullet from 25 feet away. And in following up on this inquiry by this court, I think it's interesting that in one part of Officer King's testimony, he says that he was backpedaling. And in another part of Officer King's statement and testimony in his deposition, he says that he was up against a curb. Well, which is it? Which is it? So the movement by the officer, we know by Dr. Bauer's forensic examination.
Can you, sorry to interrupt you.
Yes, Your Honor.
Can you address maybe the question that I asked your colleague to the, you know the record better than we do. But in the 2 statements that, at least that I can think about as I'm sitting here, the post statement and the deposition, there is discussion about flailing and picking at the shirt, but none of that corresponded to the moments before the victim was shot. Is that accurate?
That is accurate, Your Honor. There is no indication, and this is not a split-second type thing. Officer King followed Mr. Young around to the front of Montgomery City Hall and down 3rd Avenue, and so where exactly and when exactly Mr. Young was flailing at his shirt is unclear. It's not clear from the record that that was in the seconds and the moments leading up to the shooting.
When you say it's not clear, I guess help me understand what you mean by that.
What I mean
is there anything that I thought it was clear the other way that hadn't happened, but I'm trying to figure out what you mean by it's not clear.
The only thing that I mean there is I don't think that Officer King ever testified that he was picking at his shirt, or as it became now, reaching in his waistband just in the seconds just before the firing of the weapon, Your Honor. That's all I meant by that. Third, the district court found Mr. Young stationary when the shots were fired and not charging Officer King. Again, our expert, Dr. Bauer, doesn't say that, and again conceded that he couldn't rule out that Mr. Young was moving. What is that moving? Was that movement to the side, having to do with the bullets entering and exiting the deceased's body? What Dr. Bauer could definitively rule out was that Eric Young was not, as Officer King says, charging the officer in a closing distance of about 8 to 10 feet. Mr. Young was not wielding a weapon or known to be carrying a weapon. Officer King was noticeably larger in physical size. Fact number 6 found by the district court, Mr. Young was suspected of committing nonviolent misdemeanors prior to the shooting. And finally, fact 7, there's no evidence that anyone else was in the area at the time of the shooting. There's ample evidence in the record to support these findings by the district court. Moreover, these factual findings apply to Tennessee v. Garner, Graham v. Connor, and this court's case progeny. The denial of summary judgment was correct. I won't belabor the qualified immunity excessive force standards under Graham, but I would like to go through the Graham factors that the district court used in the denial of summary judgment. And Graham v. Connor stands for the proposition that the Fourth Amendment confers a right of free citizens to be free from excessive force in the context of an arrest or investigatory stop. And this court will look at the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, and whether he's actively resisting arrest or attempting to evade. And in this case, the court went through each of those Graham factors under prong 1. The severity of the crime at issue. Officer King admits during his deposition that Mr. King was a nonviolent misdemeanor suspect at the time of the shooting. And indeed, I would question whether any crime was committed. What was Mr. Young guilty of? He had looked into a police cruiser. Now, Officer King testifies that he had tried the door handle, but it wasn't as if Mr. Young had a tire iron out and had crashed the window of the police cruiser. So, at a minimum, you have either no crime being committed or a nonviolent misdemeanor offense of some attempt at a vehicular break-in, maybe trespassing on police property. Under Yates versus Terry, the first Graham factor weighs in favor of the plaintiff who commits a nonviolent offense. The next factor, whether the suspect poses an immediate threat to the safety of the officers or others. Eric Young did not pose an objective, immediate threat of serious bodily harm to Officer King or anyone else. Officer King testified he saw no weapon. He had no reason to believe that this suspect was armed. And Officer King opened fire on Mr. Young from 50 feet away, then fired 4 additional rounds. Factually, what's happened here, according to Dr. Bauer, is Officer King moved in a semicircle type motion toward Eric Young, closing the distance to within 25 feet when the final shots were fired. And this case is most like Wilson versus Prince George's County, 893 F. 3rd 213 at page 220, where this court decided in June 2018, and I'll come back to that date in just a moment, this court found that a jury could determine that a plaintiff standing 20 feet away and armed only with a pocket knife, harming himself, did not pose an immediate threat to the officer or others, rendering the officer's lethal force constitutionally unreasonable. Whether the suspect is actively resisting or attempting to evade arrest. In this case, we know that Eric Young walked away from the scene and walked away from the officer a number of times. I believe that Officer King even testified in his deposition that Eric Young stated, "Get the F out of my face," and kept walking. The taser was attempted on Eric Young. He was wearing a Carhartt in February in West Virginia. It's cold. That could be a reasonable reason why the officer's taser did not work. And again, the record is unclear exactly of what crime Officer King suspected. We only know that Officer King thought that it was a nonviolent misdemeanor. We also don't...
Can I ask you another factual question?
Yes, Your Honor, of course.
So when I try to read through the expert reports, particularly of Mr. Bauer, at some points he seems to suggest, by reference to an east-west direction, that the officer here was not going backward, but is instead going forward toward the victim. Is that what you understand the expert's testimony to have suggested?
Yes, Your Honor, in kind of a semicircle movement.
Right, and that's, so in other words, when we look at the set of casings that are listed in Figure 9 of one of his reports, the casings that move toward where the body is, the expert suggested that the furthest one away was the first shot fired, and that in fact the defendant was moving toward Mr. Young.
Yes, Your Honor.
Okay.
Finally, with the final Graham factor before I move into the clearly established right, obviously these are fatal injuries sustained by Eric Young. Under prong 2, the district court correctly decided that Mr. Young's Fourth Amendment rights were clearly established. And this court has held that the contours of a right become clear when an issue has been authoritatively decided by the Supreme Court or the appropriate United States Court of Appeals. And we have the general rules under Graham and Garner, and then we also have clearly established rights under case law. I mentioned Wilson versus Prince George's County, and I brought that case up for a specific reason. That case was decided in June of 2018. That also happened to be the very month that Officer King was hired by the city of Montgomery. Officer King had worked in Chesapeake, West Virginia at that municipal police department from 2016 to June of 2018. In the very same month that Officer King is hired in Montgomery, this court stated, an officer would violate a suspect's Fourth Amendment right to be free from excessive force by shooting a person who, 1, was suspected of having committed a burglary and a battery, 2, was standing about 20 feet from the officer holding a knife, inflicting harm on himself and stumbling, but not threatening others or making sudden movements, 3, was refusing to obey the officer's repeated commands to drop the knife at the time he was shot. We therefore conclude that Officer Gill is entitled to qualified immunity. We emphasize, however, that as of the date this opinion issues, law enforcement officers are now on notice that such conduct constitutes excessive force in violation of the Fourth Amendment. That is why Eric Young's rights were clearly established at the time of the shooting in February of 2019. And I know that the case was decided after, but this court's indications in the estate of Jones versus City of Martinsburg, a 2020 case, this court said enough is enough. Enough is enough of these supposed fear-based officer shootings of unarmed people. Eric Young was 50 feet away, not charging, posing no immediate threat to Officer King. Officer King skipped other non-lethal methods of detaining Eric Young and fired 4 shots at him, closing distance from 50 feet to 25 feet as Eric Young fell to the ground. Under these circumstances, there was no objectively reasonable reason for the officer to do this. So, based on all of these factors, we respectfully request and pray that this court affirm Judge Copenhaver's denial of summary judgment on qualified immunity grounds and remand this case. Thank you.
Thank you, counsel. Mr. Taylor, we'll hear from you.
Yes. Your Honor, to answer your question you left me with, Joint Appendix 60 is the deposition testimony where he discusses the flailing. Joint Appendix 342 is his written statement, his statement after that where he discusses it, and Joint Appendix 352. Those were just some of the references I found where he discusses the flailing.
At the moment, so the challenge is he says he charges at me. He puts his, I think what he says, he puts his hands up, threw his hands up and charged at me, and I shot him in his deposition. And what I don't see is I see at other points the claim of flailing, but I don't see at and around the time he's charging that he is both charging and reaching into his waistband. Do you understand the distinction I'm trying to make?
I do, Your Honor, and at 352, the last question on there, I won't read the whole paragraph, but it says, and when he started flapping his shirt up and down, I thought he was going to reach for a gun or he's going to have something, so that's why I pulled my gun out in fear that he had something, and then when he charged, I had no other choice. So it seems to me that it's happening split-second decision-making time. It may not be while he's physically charging, but he's flailing towards this, and then it's a split-second judgment he has to make as to what is going on here. He's in fear for his safety here, and this is not just he's saying, I'm in fear of my safety here. This is not one of those cases where he just declared, I'm in fear of my safety, and I'm going to shoot this man. What happened is he's sitting in his office at 4:30 in the morning, and he hears, to be frank, I won't say this.
Can I say that? I understand your closing argument point, but can I say that if I find that the officer was moving toward Young and Young was not charging toward him as a factual matter?
Yes.
At summary judgment?
Yes.
That's what I can't.
Yes, Your Honor. If you look at the cases we relied upon, see, this isn't a case where this isn't a case that is like any of the cases that the district court relied upon, because in those cases, they knew the type of weapon that the individual had. For example, in Wilson v. Prince George, the officer knew he had a knife and he was using the knife on himself. This is one of the cases, and this is more like Anderson v. Russell, where...
But the problem with Anderson and the rest of those cases is we don't have evidence that your client was telling false exculpatory claims, right? He wasn't falsely claiming, and I'm not saying as a factual matter that your client is false, right? I'm talking about the inferences that I must draw given where we are. Your client falsely claimed, I was afraid because he was charging at me, and he got to within 8 or 10 feet before I shot him, and I have to assume that both of those things are false, which means it makes it really hard to believe anything else he says, right?
But also but now you're making credibility determinations.
Yes, I'm making credibility determinations against your client because
Correct.
That's the reasonable inference for the plaintiff.
Correct, but there's nothing to dispute. So what you're taking evidence that's in the record to dispute what my officer said regarding the distance and the movement. Okay, fair. Accept those, okay? But the rest of the record evidence is the record evidence, and the court has to accept the record evidence if there's nothing to dispute it. The court cannot...
Just so I understand, the argument you're making is if someone makes numerous false exculpatory statements, this court must accept all other statements that cannot be definitively proven as false. That doesn't seem like the way we
that's-
actually do it.
The court, any court does not weigh credibility, and that's a credibility determination. So at the end of the day, we know that the individual was shot, right? And my officer said he was shot, so we have to accept that he was shot. We're gonna.
No, we don't have to accept your officer's word. We've got an autopsy.
Okay. We have shell casings that show that as well. We have a knife on Mr. Young, and multiple witnesses other than my client indicated there was a knife. There was a co-defendant that was released out that was actually the one that bagged the knife. So we know that he had a knife. So we know that he had some sort of weapon. We know that he's flailing his shirt. And so at that point in time, he's making a movement.
Let me ask this. Would it be fair if he pulled that pocket knife out 50 yards away, standing still? Could the officer execute him at that point?
No, Your Honor. But in this, and I see I'm over
I thought not. I just wanted to you just keep coming back to the knife. I don't know why the knife is relevant.
because it indicates my officer had a reasonable belief he had a weapon on him, and it turns out he was correct. He didn't know what kind of weapon because he could not determine the weapon. It's much like in Anderson v. Russell, where they made a movement. This is we don't know the presence of the weapon type situation. He makes the movement, and that's when...
It's not like those cases. That there you have testimony that he makes the movement, and as he makes the movement, I pull out my gun and shoot, right? Because it's the movement. You're exactly right. We've said in cases, it's the furtive movement that gives the suggestion he has a weapon, I'm in danger. There's not that testimony here. And I know you say, it could be crystallized, we could make it clearer, but again, we have to allow for the possibility that the jury could not believe your client, right? We have to allow for the possibility that even taking everything that your client says, there's actually not testimony from your client that's that clear about when this flailing was happening. He pulled his weapon out. The officer testified that he pulled out his gun and then followed Mr. Young for a while. That it wasn't he pulled it out and shot. So if the flailing's happening while he pulls out his gun, that doesn't help you.
Well, Your Honor, just all I'll say is, to end is, there has to be a case on point that puts this beyond dispute. And we've cited to Sigmund, Anderson, that call into question the actions. This may be a case like in Wilson v. Prince George County that they relied upon, where the court granted qualified immunity in Wilson because they said there was not a case on point. This is between a case of Clem and Sigmund. And so because it's not on point, we're going to grant qualified immunity.
This is like Wilson, except that almost every prong of the analysis, there's less to go on. They weren't violent misdemeanors, they were nonviolent. In Wilson, there was a knife and he was flailing it around. Here, no weapon was presented. I mean, it's like Wilson, but in a way that doesn't favor you.
No weapon was presented, but no weapon was determined that there was no weapon presented. It's one of those where the officer did not know. And that's why it's more like Anderson, Your Honor. Thank you.
Thank you, counsel. As you know, having been in here, we wish we could come down and greet you in person, and thank you for your help with this case. We hope that we'll be able to do so when we return. We'll go to the next case, number 21-642, Younger versus Crowder. Mr. Scott, we'll be happy to hear from you.
Good morning, Your Honors. May it please the court, my name is Robert Scott. I'm an Assistant Attorney General for the state of Maryland. I'm here today representing Tyrone Crowder, who is a former warden of a correctional facility in Baltimore known as the Maryland Reception Diagnostic and Classification Center. We're here today to ask you to reverse a judgment in the amount of $700,000 that was entered against Mr. Crowder personally based on the actions of 3 other correctional officers at the facility. The judgment was entered against Mr. Crowder based on the unprecedented and unforeseen attack on several inmates by these 3 subordinate correctional officers. The judgment was entered against Mr. Crowder even though it is undisputed that he did not participate in this attack. In fact, he was not even present in the building when it took place. There was no evidence presented at trial that Mr. Crowder approved the attack or had any advanced knowledge of it. The evidence shows that Mr. Crowder did not find out about the attack until well after it took place.
Can you help me with, you said there's no evidence in the record that he approved of it. And there is testimony about some people thinking he was at roll call and that he said, why do my officers look like this and my prisoners look like that? There seems to be, this record is replete with disputed evidence. There seems to be a dispute about whether he was at roll call, whether he wasn't. A lot of officers thought he wasn't. Somebody thought he was. What do I do with that?
There's no testimony that indicates that he was present at the roll call.
I read it, there was. So what do I do with that?
Okay, which witness are you referring to, Your Honor?
It was in the trial. I don't have it in front of me. That's something you should be telling me, but thank you for the question.
Well, Mr. Hanna testified that he was not present.
Can I ask it differently? If there was such testimony, do you lose?
Well, it would depend on what he said, Your Honor, but I don't believe there's any testimony indicating that Warden Crowder at that morning roll call said anything. There were allegations that he was at roll call initially. In fact, if you read the initial complaint, before the amended complaint, the allegation was just as Your Honor just described, that he held up photographs of the officer who had been attacked the previous night. But when you get right down to the trial testimony...
Why don't you look at JA 1107? And this is the testimony of Officer Hanna, who testified that Crowder spoke at the roll call for the night shift following the assault and asked, quote, "Why do my inmates look like this and my officer looks like that?" End quote.
Right, and he's subsequently asked, do you have any personal knowledge of whether Warden Crowder was at the roll call? No, I do not.
Right, he says he heard it from other people.
Correct.
That's 1107, crossover to 1108.
Right. Again, Your Honor, he wasn't there. He testified that he was not present
Was that
at the roll
stricken?
call.
Could the jury consider that, or was that stricken from the record?
It was not stricken, Your Honor.
So the jury could consider that evidence?
It was not stricken, that's correct.
Right.
Right. But that does not indicate that he had advanced knowledge of this attack.
But you said that there's no evidence that he condoned it.
No, that he approved it in advance, correct.
You take that not as approval? I mean, let's hypothesize that we have a video of Officer Crowder at roll call for the night shift following the assault. And in it, he says, "Hey, officers," in his best Jack Nicholson voice, "why do my inmates look like this and my officers look like that?" And you think if that was on video and we knew he said it, that wouldn't be condoning and or ordering implicitly the attack?
Well, we don't have that video.
I'm asking the hypothetical.
Your Honor, if that had happened in this case, we'd have a different case.
And I'm asking, if that happened in the case, do you agree that you would lose?
I would agree that someone could conclude that if he says it in that menacing voice, and there's a video of it, that he knew in advance. That this
what about if he said it in a sing-songy voice? Do you really think that that's the determining factor?
Well, I think the video, we don't have a video here. What we have is we have testimony from somebody who wasn't at roll call about what happened at the roll call based on what somebody else said who's not identified.
Okay, and I'll ask one last time, and then I'll just take your refusal to answer as, acquiescence, is that if he said that, do you agree you lose?
No, Your Honor.
Mr. Scott, let me ask you, I know the IIU investigation wasn't always flattering to Warden Crowder, but I do think they found that he did not have advance evidence of the risk of retaliation or the retaliatory attack. Am I correct in that?
That's correct, Your Honor. Detective Sage's report, which was offered in evidence by the plaintiff, concluded that he did not. And the report takes fault with Mr. Crowder for certain things he did after the assault, not responding quickly enough, not investigating quickly enough, and takes fault with the fact that Mr. Crowder didn't transfer these inmates out of the institution immediately. But it does not say, in fact, it does not conclude that he had advanced knowledge of this attack, and no witness with personal knowledge of what took place testified that Warden Crowder knew about this.
And it's an important point, isn't it, as we try to figure out what this clearly established set of conduct that should have put him on notice that he was not acting properly or violating constitutional rights here.
As near as I can tell, what the plaintiff's argument comes down to with respect to our qualified immunity defense is that there was a clearly established right by Mr. Younger to be transferred out of MRDCC that night to another facility. And Detective Sage, who conducted his investigation of Warden Crowder, admitted in his report, acknowledged in his testimony, that there was no written protocol requiring that these inmates be transferred out that evening.
In fact,
Plaintiff's
Ms.
own
Hinton
expert-
said, excuse me, Ms. Hinton actually said that his response was reasonable. And the expert witness for Mr. Younger, I think, Mr. Leach, said his response was reasonable in not transferring.
That's exactly
So
right.
no advance notice of this potential for retaliatory attack, and response was reasonable.
Correct. You're right. That's right, Your Honor. I mean, the most that was shown here was that Warden Crowder was perhaps negligent after the fact and not.
Do we have to
taking enough
accept those
actions.
things? So I understand that, there's an officer who says he acted reasonably, but we've got a verdict that says he didn't, right? I mean, so I have a little hard time understanding, given the posture we've got to take the evidence as found by the jury, and if the jury believed all of the things that the officers here testified about how reasonable Crowder acted, they couldn't have convicted him, right? So don't we have to assume that they were not accepted by the jury?
Well, Your Honor, he wasn't convicted. He was found.
I'm sorry.
Responsible.
Former prosecutor, my apologies.
He was found deliberately indifferent to a substantial risk of a retaliatory attack taking place against Mr. Younger and other inmates. And this is an incident, all the witnesses who testified who worked at the facility said that this attack was unprecedented. Nothing like this had ever happened where you had an attack, a pre-planned retaliatory attack taking place the next day.
And I understand you have a sufficiency of the evidence argument, but isn't that all about sufficiency of the evidence? If we disagree with you on sufficiency of the evidence, don't we have to forget all that stuff and accept that your client was deliberately indifferent to the serious risk of the attack? I mean, that's what the finding was. Now, I understand you got a sufficiency argument, but if we get past sufficiency to qualified immunity, we can't relitigate sufficiency, right? We have to say your client was deliberately indifferent.
Right, but then the question becomes, Your Honor, what's the clearly established right that vitiates the qualified immunity here? And there isn't one. I mean, there's no constitutional right to be transferred out of a prison that night in an emergency fashion. I mean, the inmates who were involved in this incident were put in segregation. That's what the warden knew that evening. That's what he was told. And he made his decision based on that. So what's the clearly established right that was purportedly violated here? And if there isn't one, then Warden Crowder is entitled to qualified immunity.
How does the appellee describe the right, define the right?
It's unclear to me, Your Honor, when I read their brief. I mean, I think they basically, they say he shouldn't have been attacked. I mean, nobody's disputing that Kevin Younger shouldn't have been attacked. That's not our argument. The argument is, what was the clearly established right that was purportedly violated here? That's what they need to
Can I ask
overcome.
maybe again another hypothetical? And I accept their hypotheticals, okay? But if I read Slacken and Shaw to establish a right that sounds something like, a supervisor who's aware of a serious risk of attack by his supervisees, but does nothing, violates the victim's constitutional rights, except that I say that, I understand you disagree with it, but accept that. Do you think that would be met here if that was a clearly established right, and if I accept that there was sufficient evidence to find your client deliberately indifferent, would that be sufficient? I understand you're going to fight the premise, but come back to that in a minute.
Well, I mean, Your Honor, I guess I won't even fight the premise. I'll just say the evidence here isn't that Warden Crowder did nothing. I mean, that's their argument, but that's not what the record shows.
But how do I understand the finding that he was deliberately indifferent, right? Like, that is, he knew of a high likelihood of the attack and did nothing. That's what they would have to have found to find him not guilty, I apologize, but to hold him responsible in a civil sense.
Well, yes, except there also has to be a causal connection between the deliberate indifference and the injury.
That's right, and the jury found that. And so we have to assume it happened, right? I mean, at this stage, I get right? I'm trying to isolate the qualified immunity.
The question is there sufficient evidence for the jury to find that? And it's our argument that there was not, because Warden Crowder was told and confirmed with his staff that these inmates who were involved in this attack were put in segregation that night, and he was told that the officer was doing a report and was going to go to the walk-in medical clinic. And based on that, he made a decision not to transfer the inmates out until the next day. So
do you agree that your qualified immunity ultimately just turns on your sufficiency of the evidence claim? I mean, I tried to ask it as a hypothetical, but you want to argue the sufficiency of the evidence, which is fine, but do you have an argument that is separate from the sufficiency of the evidence, or do I just, at that point, say, if you lose on sufficiency, do you also lose on qualified immunity?
Yes, Your Honor.
Okay, that's what I'm trying to get to.
Our argument is that this is not that there's not a clearly established right that was violated by the refusal to transfer, the failure, rather, to transfer the inmates out that evening.
Okay, can you take, well, I'll come back to you. Thank you very much, Mr. Scott. Mr. Honig?
Honig.
Honig.
Thank you.
Thank you, we're happy to hear from you.
Thank you. Good morning, and may it please the court. Alan Honig on behalf of the appellee, Kevin Younger. This court should affirm the jury verdict below and the judgment that was entered and leave that verdict undisturbed. Importantly, we're here on a sufficiency challenge, not on a Rule 59 challenge. And so assessments of the credibility and the weight of the evidence are not for today. And what we heard just a moment ago are closing arguments restated. Arguments about belief, arguments about weight, arguments about quality of the testimony. Judge Rushing, I believe you commented early on that this record is replete with disputed facts. I would submit to this court that every fact, material and otherwise, was in dispute for this jury. Because every fact was in dispute for this jury, summary judgment was denied, and the jury was asked the ultimate question, to which it responded, Mr. Crowder was deliberately indifferent or criminally reckless to the known risk of malicious attacks by his subordinate officers to prisoners at MRDCC like the plaintiff. This case is not about an emergency transfer. The emergency transfer was the final nail in a 4-year chain of notice events to which Mr. Crowder refused to respond. And to be very clear, if it didn't come across in the letters of our brief, the right to be free from malicious attacks by correctional officers was a clearly established right, as this court said in Thompson versus Virginia, which is a 2017 case, but this court in that case said that that was a clearly established right since 2010.
But the warden isn't Green or Ramsey or Hannah, right?
Of course not.
What notice did Warden Crowder have regarding this established right that you're talking about as it would apply to the warden in supervisory liability?
Yes, Judge Leiden. So there are two tranches of notice, if you will, that we presented to the jury as far as the warden himself goes. There are the 4 years from 2009 to September 29th, 2013, to the day of the correctional officer attack, the Ganayu incident. In those 4 years, we presented to the jury 8 distinct notice events brought to Mr. Crowder by various supervisors, subordinate supervisors, and superior supervisors. And over the course of those 4 years, Mr. Crowder's staff came to him and said, "You've got a problem here. You've got a general problem, a systemic problem, a culture problem, where people around here don't like to do their jobs correctly. Supervisors don't like to supervise. Staff do whatever they want with impunity, without fear of consequence, because nobody gets disciplined, or at least discipline is put on hold around here. Because this was a lawless prison environment. And we didn't impose a divining obligation onto Mr. Crowder. In other words, we did not suggest that Mr. Crowder should have read between the lines, should have been reviewing documents and come to these conclusions himself. Beginning in 2009, when Mr. Crowder was assistant warden, his warden, who testified at trial, Ms. Hinton, said, "I noticed a problem with Officer Green."
But that's interesting that she noticed that before this ever happened. But yet when Crowder calls her after finding out about the attack on the correctional officer, she doesn't bring that up. She doesn't suggest a transfer. And she finds his response reasonable.
I'm glad that you brought that up, Judge Leiden, because if you read the transcript about that alleged phone call, I can point you directly to it. It's at Joint Appendix 1815, right around that part. The jury was free to disbelieve Mr. Crowder about ever making that phone call to begin with, because what Ms. Hinton said is, "I don't recall ever talking, I for sure never had a conversation with Mr. Crowder on the night of the Ganayu incident about a transfer. Of that, I'm certain. And I don't even recall ever talking to Mr. Crowder about the Ganayu incident on the night that it happened." The jury was free to, and that's the whole point, Your Honor. This is not a Rule 59 challenge. This is not a who's right or who's wrong. This is, was there evidence for a jury to reasonably conclude in its exclusive fact-finding province that one side was right and one side was wrong? And that's what happened here, and that's the only thing that this court can review.
She doesn't change her testimony though regarding, or she does indicate that his response was reasonable.
She indicates his response was reasonable based on the question posed to her of, if this was all of the information that Mr. Crowder was provided with on the evening that Ganayu was attacked, and to be clear about what that information was that Mr. Crowder said, the only thing I knew that night was that Officer Ganayu had a bump on his head and a scratch on his lip. So Ms. Hinton said, if that's all that he received, and you mentioned to my colleague also, our expert, Mr. Leach, made the same comment, it was reasonable. If that was all that Crowder heard, then his response was reasonable. I have to go back for just a minute to the argument that precedes us, and Judge Richardson, you brought up to counsel that when a statement contains an if, the jury resolves the if. Because here with Ms. Hinton and with Mr. Leach, if Crowder heard bump on the lip and cut on the head, then his response was reasonable. But a jury's free to disbelieve that. And if it's not...
Do you think it's true, if the jury did believe that, could they find him deliberately indifferent?
If all that we had was the Ganayu incident, perhaps. But we have 4 years that predate the Ganayu.
Perhaps. Which way? I'm sorry.
Well, to answer your question, Your Honor, if
I said, could a jury find, if that's all the information that Crowder had? Maybe I'm not, which direction? Sorry, go ahead.
Well, if a jury could reasonably find, as to his response to receiving information about Ganayu, having a cut on his head and a bump on his head and a cut on his lip, that his response, if that's what he heard, was reasonable. Of course, that's within the province of the jury, and the jury could equally reasonably conclude the opposite, which they did.
So I thought you would be stronger about that. I thought you'd say if all we had was this one incident, so if there were no prior incidents, then not only could a jury not find him liable, but a judge would grant summary judgment. Because if it's only a single incident and it was a bump on the head, that like standing alone wouldn't be sufficient. The problem is that's not what we have.
Certainly, Your Honor, and that's where I was going. 100%, and this was the strategy at trial too. When you take these notice facts in isolation and put a silo around them and present them to the jury as if they existed in an echo chamber, perhaps what Your Honor just suggested is correct. That if all we had was the Ganayu incident and Mr. Crowder hearing, it was a minor, not a big deal, then it would probably be error as a matter of law to deny a Rule 50 motion. I would agree with you there. I would state it as follows, Your Honor. If the Ganayu incident never happened, and all we had was 4 years of repeated, explicit notice about the same correctional officers maliciously attacking prisoners at MRDCC, Judge Bennett correctly would have denied the Rule 50 motion on those facts. And so you can remove, for the purposes of your review, the Ganayu incident in its entirety.
Let's imagine that you have the very facts that are at issue here, like everything that's happened, and Crowder, upon hearing this, immediately issues a order that these inmates are not to be touched. Would that have sufficed? I'm trying to figure out what you think. One thing they could do is transferring, but another thing in theory they could do is order that they not be touched.
Sure, an admonishment, aside from being reasonable correctional practices, the jury heard, certainly would have weighed in favor of a finding toward Mr. Crowder. That's correct. However, what we have here is not just no admonishment, not just going to bed that night as if nothing happened. Mr. Crowder made a specific order, despite a department regulation to the contrary that says thou shalt immediately transfer when this type of an assault happens on a correctional officer. And in fact, the violation of that regulation was the basis for the disciplinary action against Mr. Crowder that led to his ultimate demotion. So
let me ask you, was it the assistant warden that told Mr. Crowder that night what happened?
No, Your Honor, it was a captain by the name of Miss Boyd White from the MRDC facility who called Mr. Crowder, the record evidence showed, within 10 minutes after the Ganayu attack.
Okay, am I correct that the assistant warden, when he was told about it, thought it was not a major incident either, thought there were minor injuries, or as you put it, bump on the head sort of type situation? Wasn't that the assistant warden's testimony?
Well, the assistant warden testified that that's what Crowder told her. What the assistant warden told the jury, and it's cited in our papers and it's well established in the record, is, and this is why all of the facts are in dispute, but what the assistant warden said is that the captain makes a phone call from MRDCC to Crowder. Bypassing her, she should have heard first, but for whatever reason they call Crowder, and what Crowder told the assistant warden was, I just heard it was a minor thing. What the captain told the assistant warden was, I told him that Ganayu was, quote, in bad shape.
Okay, got it, thank you.
And so a jury, as I said before, it's only for the jury to resolve these weight issues, these believability issues. Going back to the notice.
Can you talk for a second about Judge Rushing's question from earlier? This testimony about Officer Hanna, which is sort of the hearsay that maybe Crowder was at roll call and said, you know, why do the inmates look this way? The record evidence seems pretty strong that he was not at roll call that night, and yet it's in the record. There's no hearsay objection. It was never struck. What do I do with that? And can I rely on that, or should I not rely on it given the overwhelming evidence that he was not at roll call, right? I mean, it seems a little hard to believe.
I would suggest to you, Your Honor, that as I suggested to the jury, that that's not a fact that's necessary to find that Crowder had either advanced knowledge of a pervasive risk of harm or that his response was inadequate. The bottom line is that we presented many pieces of evidence that preceded the assault and that followed the subject assault that show MO, that show mannerism, that show habit and practice, and that the way in which Mr. Crowder responded or chose to ignore glaringly obvious notice facts was present far before and far since the subject attack. And those things, again, helped the jury to resolve credibility issues and believability issues when Mr. Crowder presented a picture that, according to him and from his vantage point, he never had an issue. That was his testimony. I never had an issue at MRDCC. Well, the jury was presented with that picture on the one hand and the picture from 12 supervisors who testified in open court to the contrary of Mr. Crowder on the other hand. And it was up to the jury to decide, because all of Mr. Crowder's supervisors in real time noticed and appreciated the pervasive risk of harm. We don't have to imagine that.
What did those supervisors say about whether this was an unprecedented attack?
As far as the subject assault on the prisoners, it was unprecedented. Yes, many of them said it was unprecedented, but unprecedented doesn't fall into the supervisory liability calculus. What the supervisory liability, nor does motive, by the way, but what the supervisory liability calculus asks is, was there knowledge of a pervasive risk of harm? Here, the pervasive risk of harm were malicious attacks by correctional officers against the prisoner population. There was express, repeated, actual knowledge and notice given to Mr. Crowder by all of the people around him. And Mr. Crowder's response...
What did you interpret the reference to unprecedented to mean? I mean, because you could read unprecedented a couple of different ways there. So when they're saying the attack on the inmates was unprecedented, how should we understand that?
Yes, Judge Richardson, that is an attempt to raise the standard for supervisory liability, and specifically for the notice required for supervisory liability to attach to something far beyond what Farmer and Shaw and its progeny have ever contemplated. Namely, that in order to have notice of some type of risk of harm, you have to know that it was a premeditated, retaliatory, concerted, coordinated, conspiratorial attack. If that was the standard, the Supreme Court would tell that to us. Rather, what the Supreme Court says is that it's a pervasive risk of harm that's fact-dependent and that's circumstance-dependent, because what's unreasonable or what might cause those notice facts to rise to the level of constitutionally problematic in one instance may not in the next. And
Well, it seems to, I don't think there's a dispute that it was unprecedented to have a retaliatory attack. People said, well, actually, there may have been one witness who said there were lots of those, sorry. But by and large, the witnesses say they were unaware of a pattern of retaliatory attacks or vigilante justice. Now, they were aware that officers were beating up, detainees, but not for retaliation. If that were the case, does that still meet the standard of sufficient knowledge?
it certainly does, Your Honor. And I would point this court back to its decision in the Thompson case in 2017, where it says in no uncertain terms, prisoners have a right to be free from malicious attacks not only by other inmates, but by the very supervisors who jail them. That's what, and this court did not expand or articulate anything beyond what I just quoted. That's the standard. That's what Judge Bennett applied below. He did so correctly because all of the facts are in dispute. He asked the question, which is what Rule 50 requires, can reasonable minds look at the same evidence and differ? Your Honors, we have to look no further than the procedural posture in which we stand here before you today. We have the Maryland Office of the Attorney General, who has been in this case representing Mr. Crowder since day one. They've looked at the evidence presented, and they come to one conclusion. We have a properly instructed jury, and we have Judge Bennett, a seasoned judge in the District of Maryland, on the other hand, who looked at the same evidence and concluded the opposite. By definition, Rule 50 has to be denied because reasonable minds differ. And unless there are further questions, Your Honors, I would ask that you affirm the judgment below. And because the jury found Mr. Crowder to be deliberately indifferent, this court's decision in the Granado case in 2020 disposes of qualified immunity, because in Granado, this court held that when an individual acts maliciously or recklessly in violating somebody's fundamental rights, that person forfeits his or her right to qualified immunity, which is what happened here. Thank you, Your Honors.
Mr. Scott, we'll be happy to hear from you.
Thank you, Your Honor. I just want to address a couple of things. Counsel says that there were 12 supervisors who purportedly testified that there was a pervasive risk of harm in this institution. That's not correct. There were not 12 supervisors who testified to that. In fact, the witnesses that they're relying on said things that were very different than that. Assistant Warden Fisher, they put her on the stand, and she testified about a time when she had expressed a concern to Warden Crowder that Green and Ramsey were appearing in use of force reports. And this is held out somehow as evidence that the warden knew these guys were using excessive force. That's not right. A use of force report is a report that's required to be filed anytime a correctional officer has to use force on an inmate. This is a correctional institution. Using force on inmates is sometimes required to do the job. And the regulations are, when you do that, you have to fill out a form. That doesn't mean there's excessive force.
But Crowder was reviewing those, right? And so he would see those same names coming up.
It was part of his responsibility to review those reports, absolutely. But there's no evidence that any of those use of force reports said anything about Green and Ramsey using excessive force. Those reports were not put in evidence. Their expert did not make any assessment of those reports. It's just innuendo. Oh, there were these use of force reports that Green and Ramsey appeared in, and therefore they must be bad guys, and the warden should have known. Well, even if let's take it a step farther. Let's say they're right, and the warden, what was he going to do? He knows that Green and Ramsey are appearing in use of force reports. If it's not a documented violation, there's nothing the warden can do. The testimony at the trial was clear. Once there's an investigation commenced into an allegation by an inmate of excessive force by IIU, which is the Internal Investigations Unit, the warden is no longer involved. And he can't take any disciplinary action until that investigation is concluded. And that investigation has to be concluded within 90 days. Otherwise, the officer can't be disciplined. So their theory seems to be based on uninvestigated claims by inmates that the warden was supposed to do something to prevent these guys from working in the institution. Well, the testimony was clear. The warden can't transfer them out of the institution. He could put them at the front desk at the metal detector or the control center. But he has the power to do that. But if the warden were going to reassign a correctional officer every time an inmate made a complaint about that officer, the warden's not going to be able to run the institution. The other thing I wanted to...
Can you talk about Hannah's testimony in that same context?
Yes, Hannah's testimony made clear that none of the information he was conveying was known to Warden Crowder. He never talked to Crowder. He never reported any of this alleged conduct to Crowder. As high as it went, according to Hannah's own testimony, was Lieutenant Singletary. He claims that Singletary knew about this stuff that he claimed he was doing, which was obviously a violation of the protocols and such. But there's nothing to tie it to Warden Crowder. In fact, Hannah says, well, I was told not to write reports. Well, if that's true, that explains why Warden Crowder didn't know about it, because he was engaging in this conduct and then not doing reports. There's nothing to tie any of that to Crowder. And all the other the employees who worked there testified that there was no such vigilante culture at the prison. Hannah is the only person who made that allegation.
Hannah did have really, really strong things to say. Did he cooperate against Ramsey and Green in their criminal case?
I believe he was a witness for, yes, Your Honor, yes.
Okay, that's not something you just readily knew, though. I was just curious about it.
He was a witness in the criminal case, yes. He gave testimony. And all three of them were convicted.
He pleaded.
pleaded.
Hannah pleaded guilty. Was his plea agreement part of any sort of impeachment or was that discussed in the?
I mean, I asked him on cross, he admitted that he had convicted.
I just wondered if he got any sort of credit for cooperating.
I don't know the details of the plea agreement.
It's sort of a prosecutor
I think
question.
he ended up with he had to fulfill some conditions and then ended up with a PBJ if he did. But I don't know how that all came out.
Can I ask you one question about
Yes, Your Honor.
exhaustion? That we haven't talked about, but I think we
Yes.
haven't talked about it for good reason. I just want to confirm that my understanding is correct. Crowder's post-trial Rule 50B motion did not mention exhaustion, right?
The written renewed motion did not, Your Honor. The motion that was made verbal motion that was made at the conclusion of all evidence incorporated by reference the summary judgment motion which had been filed, which did raise exhaustion.
But the post-trial, post-verdict 50B didn't.
No, it did not. It did not. The other thing I wanted to point out was we also heard from counsel that there was this clearly established protocol that the inmates were supposed to be transferred out that evening. Detective Sage testified, this is at JA 993, that there was no such protocol in place at this time. So their own witness testified that this protocol did not exist, and so therefore there's no clearly established right to be transferred from the facility that night. Warden Crowder took what he thought to be reasonable steps based on what he knew, which was there were 2 inmates involved in this assault, no weapons were used, and the inmates had been placed in segregation. And with that, unless the court has any other questions, I think I'll simply ask that the court reverse and vacate the judgment entered in favor of Mr. Younger against Mr. Crowder. Thank you.
Thank you, counsel. As you now know well, having listened to 3 of these, we wish we could come down and shake your hands and thank you. It's a tradition that we value a great deal for the civility and engagement with our bar, and we hope to do it soon, and we'll hope to see you back to be able to do it with you. With that, the clerk will join court for the day.